for September 15th, 2020. David, before I read my announcement here, would you mind sending Anthony the web user link for him to log into the meeting? And hopefully he can do that while I'm going to read through the introduction to remote meetings.
Sure thing.
I'm Carrie Martinek. I'm chair of the planning board. This open meeting of the planning board is being conducted remotely, consistent with Governor Baker's executive order of March 12, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate the transmission of the COVID-19 virus, the town of Northborough has been advised and directed by the Commonwealth to suspend public gatherings, and as such, the governor's order suspends the requirement of the open meeting law to have all meetings in a publicly accessible physical location. All members of the planning board are allowed and encouraged to participate remotely. The order allows the planning board to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. The public is encouraged to follow along using the posted agenda. Members of the public who wish to view the live stream of this meeting may do so by going to Northborough Remote Meetings on YouTube via the link listed on the agenda, by tuning into cable access television government channels, Verizon Channel 30 or Charter Channel 192, or by visiting the town's website and going to the Department of Cable Access Television and click What's Playing Live. If you're on the phone, please dial *9 to raise your hand. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. I'd like to confirm that the board members and anticipated people on the agenda are here. Please confirm that when I call your name, please respond in the affirmative. We have Millie Milton.
Here.
Amy Pretsky.
Here.
Michelle Gillespie.
Here.
Okay, we don't have Anthony yet, so hopefully he gets on in the next few minutes. Staff, when I call your name, please respond in the affirmative. Kathy Jubert.
Here.
Fred Litchfield.
Here.
Bob Federico.
Here.
Okay, great. We have everybody. And we also have today our town council, David Dineski. If you could just respond in the affirmative that you are here as well.
Yes, good evening.
Good evening. Okay, great. So let's see. The ground rules are, I will invite each speaker on the agenda by name to make a presentation and speak to their application. Participants will provide their full name and hold until their name is called. Each speaker will be asked to mute their phone or computer when not speaking and to speak clearly in a way that helps generate accurate meeting minutes. Those responding will be asked to wait until the floor is yielded to them by the chair. Speakers who wish to respond to the comments of others do so through the chair, taking care to identify themselves. Each vote taken by the board or committee will be conducted by a roll call vote. So let's see, I will ask members of the public who wish to speak to identify their names and addresses only. Once I have a list of all public commentators, I will call on each by name and afford 3 minutes for any comments. There's no executive session this evening. If technical difficulties arise, I'll suspend the meeting while attempts to resolve are made. Any connections or disconnections, reconnections or disconnections should be accurately reflected in the meeting minutes. Okay, I want to make sure to speed through that because I know we don't have a lot of time with town council, and I want to get started with the first item on our agenda, which is a discussion with town council. So when we last left, we were discussing our site plan approval process in addition to our special permit for site plan approval process, and the board had some questions about that. And so that the board is aware, I did have the opportunity to meet with Mr. Dineski yesterday alongside with Kathy Jubert, and also John Kadir was able to attend the meeting. And we had a conversation for a few hours yesterday. So what I'd like to do is give the board a chance to ask some questions this evening during this time. I may have a couple of questions as well, but I wanted to first check in with board members. I think everybody received the memos for this evening. So if we want to start, why don't we take a look at the memo that first came through, which was the yesterday. I think we got that yesterday about the site plan approval process. The subject line is site plan approval and uses subject to special permit with site plan approval. So this actually pertains, then this first scope piece pertains primarily, I think, to the Starist application. So if any of the board members have questions about this memo or additional concerns that we had from last time that you'd either like answered or we need some sort of follow-up to note.
Carrie, can I just remind the board members too that you
you have to speak in general terms during this part of the discussion because you're not in a public hearing for either one of the projects that these memos pertain to.
Okay. Okay. Millie, do you have any questions?
I don't. I actually don't see that I got that memo, so I'm trying to find it.
Okay,
Um,
so, oops, there's Anthony. Okay, Amy, while she's looking, do you have questions?
I think I got it.
One of the memos I sent out last night to the board, which it's dated September 14th. And then the second memo I sent out earlier this afternoon, and that's dated September 15th, and using all of your town email addresses.
Last night, site plan review memo. There it is. Okay.
Okay. Amy, do you have questions that you want to ask?
I'm not sure if I have questions yet on Steris. I have more questions on Bartlett, I think.
Okay, well, generically speaking, it would just be about site plan use. Michelle, do you have questions on the first memo, the site plan, scope of site plan review?
So I'm just reviewing, Kathy, are you talking about the email that you sent out with regards to Dave has it dated September 15th? Special permit requirements for groundwater protection overlay. Is that the one you're referencing?
No, we'll reference that next. The first one is from an email that I sent out to all of you last night. And that also contains a memo from Dave Dineski, and it's titled Site Plan Approval and Uses Subject to Special Permit with Site Plan Approval.
Okay, so last night.
So last night you want to look between, say, like 9:30 and 10:30.
Okay, well, you
Got
look
it.
at that. I'm going to see, Anthony, do you have any questions? Oh, Anthony, we can't hear you.
Sorry.
there you
Okay. There we go. Yeah. So, and I, again, so now I'm a little confused about, I'm not certain what we can ask and can't ask based on what Kathy just said. But my
If I
concern.
can interject for just a moment, Madam Chair, I think the point is that we should be speaking in general terms and not about the particulars of a single application. And that's really just a sort of due process issue since it's not part of the hearing for either of the applications, but certainly the provisions of the bylaw as are referenced in the memos are appropriate for discussion.
Okay, so then I guess I'll try to frame it generically, maybe to help put it down a path where we're actually speaking generically, not about a specific application. In terms of whether or not, over time, in a case where the board has concerns about the use, where they question whether or not the use originally determined, as the hearing has continued or as time has gone on, the board is questioning whether that use is in fact the use. Originally, town council had indicated that, there are certain restrictions with particular uses, like for example, light manufacturing, and there are also performance standards. So from the original decision the original opinion that we got from town council, it sounded like if there were questions of use, those are some tools that we could look at. They weren't specifically addressed here in this memo, I don't think, but are those still tools that the board can look at? And I think, did you get a chance to look at your original opinion?
I did. I looked at it briefly. I will say I actually had to spend more time looking at the other water protection special permits that were forwarded, but I didn't review it in detail, but I did look at the issues that were raised.
Okay. Do other members of the board have anything related to when we are considering use? Any questions about that? Because we took this road in the beginning and, are there any related questions that we need to address?
I guess, I mean, the only question I have is, can we challenge an interpretation by zoning enforcement?
Meaning the zoning form
The use.
that accompanied.
Right.
So I think if the board were to say that it's in an application not agreeing that the use for which site plan approval is requested is an allowed use, then it would first want to have reason to make that determination. And secondly, as a general proposition, if someone asks for site plan approval for a use that the board determines is not allowed, then one would presume that site plan approval would not be given. But that difference or challenge of that zoning opinion, again, is something that would need to be supported by some evidence and some form of documentation or information so that there is a basis for everyone to know the reason that the board is disagreeing.
So in that case, I feel like we've been asking for data and facts to support that it is the correct use as part of our overall review. It seemed like that's what you were saying for us to do in the original opinion. Is that, in order to make that case, if we want to see data and facts that prove it, is that part of what we're talking about here?
Yeah, there's sort of a line, and it may not be a bright line, but I won't be able to give you the references since I'm driving and can't be looking at anything while I'm speaking. But there is provision in the bylaw for, at the time of building permit application, a request for data or documentation to demonstrate compliance with what I'll say are performance standards in the bylaw. So if a use has been presented by an applicant and that use has been described as use by the building inspector, zoning enforcement officer, then there's a presumption there, I would say, that that's the use that we're dealing with. And certainly some general inquiry about the use as a matter of information would be I think, reasonable and typical exercise for a board considering an application. And then there's also a more, I guess, detailed level of inquiry that's described at the point where a building permit is requested, because just, again, generally, if there were a site plan approved for any particular use and then a building permit is issued and a person wanted to contest the use, that person would have a right to appeal the building permit issuance to the Zoning Board of Appeals.
So Anthony, does that answer what your question?
Well, I just mechanically, I don't understand how you get from point A to point B if that were the case, and who would be doing what. I mean, at the end there, I heard that it would be appealing to the ZBA, I believe is what I heard. But I know there's.
That would be a building permit
Okay.
appeal.
And there time limitations on that?
That appeal would be the usual 30-day appeal.
From the date of the interpretation?
That's from the date of a building permit issuance. What I was referencing is that a building permit is a decision or an action that is appealable on a zoning basis to the Zoning Board of Appeals. And that's the provision that's included in the zoning act.
Does the planning board have standing in that kind of appeal though, a building permit appeal?
There's a right of appeal to town officials or boards in general with respect to decisions.
So then if you don't mind, I have two questions, unless other board members, do you have any questions that you want to jump in on? I don't want to. Amy?
Well, I just don't know. How does one know even when a building permit is issued? Like normally our applications go through and say things are approved. The applicant goes in for a building permit, but we're never told. Like, no, we never know when someone pulls a building permit. So I don't even know how the 30 days would start if we are never even notified.
It starts by statute when the permit or a decision is made. Now, administratively, you could ask for or have prepared, just get a list of whatever permits might be issued in a particular week, but there is no requirement to a board or to an individual or the public in general for notice of the building permit. So in that sense, that kind of action is something that if you were interested in, using the word you in a general sense, you would monitor in some way.
So, and I think you said that the zoning interpretation sheet, in your original opinion, you said on its face says that it's just for information. You can't appeal that. It's not a decision you can appeal. It's just the information sheet.
Right. I think that's I believe it was just, as you say, the words that are on the document. And I don't think that that's ever been considered as a particularly appealable action. I understand that, and Bob can certainly correct me, or Kathy, that that's used as an administrative tool to help guide the overall permitting and zoning approval process.
Yes, that's correct. That's not anything that's required by statute. That's something, I mean, I let Bob speak for himself, but that's something that the building department does to assist in the, application process.
The zoning enforcement, the zoning interpretation forms, if everybody's read it top to bottom, is an interpretation and an opinion. And it is not a permit to do anything. It is not permission. It is not a violation. It's not anything. All it is an informational guide to, in the interest of customer service, to help navigate the waters for an applicant who wants to do a project.
Mhm.
Okay. Everything on that sheet is up for interpretation and debate because it is not a rule and guide. I'm not obligated to do these sheets at all, but I do it as a matter of customer service, and I do probably 10 of them a week. Okay. Mostly, can I put the pool here? Can a nail salon go over here? That sort of thing. On the more complicated ones, such as the two that we're talking about now, I usually fill those out with the assistance and the input of the engineer and the planner. Like I said, those interpretations are not made in a vacuum because I have not been here as long as the other two have.
No, of course.
And I rely on a lot of the institutional knowledge that's going on in this town. So the interpretation forms are just an interpretation. That's exactly what it is. It's not a determination.
Got it.
It's not a rule and guide, and it's not a permit to do anything.
I do have one question, Bob, about those sheets. When you put a list of what permits are required, like you usually say you might need a variance or it might need a groundwater permit.
Mhm.
How do we know if those are supposed to be the correct ones? Is that component of it what's actually required, or like sometimes?
When I put those variances, special permits, and things like that, I follow the rules that are in the zoning book.
So you're looking at
Okay.
the bylaws when you put that down.
Well, where else would I look?
I know, fair point, Bob. Okay, I get what you're saying. Okay, just two questions I wanted to ask. Dave, are you still there?
Yes, if I cut out, it might be briefly because I'm in a poor reception area, and if that happens, I'll call back in.
Okay, let's see. But my question was, I know you wrote a lot about the use being indoors. And the question that I have, if in a case where, where you have a physical product, you can easily see with your eyes that it's indoors. But if you have something like gases or things that you can't see, that you don't know if they're indoors or outdoors, how do you approach that at a site plan level to make sure that once it gets outdoors, is that when it becomes part of site plan?
Well, let's say the byproduct, to use a general word, of a use, I wouldn't see that as a site plan issue because it doesn't relate to the physical condition of the site or configuration or the layout, design, et cetera, on the property. That's more a component of the use itself, which is not what the site plan process allows for review of.
But so if I made, 20,000 widgets and I threw 10,000 of the 10,000 of them out the window, and that's where they were to remain, is that allowed?
That may be a question of whether you're complying with what the allowed use terms are, but I don't see that as a component of site plan.
Gotcha. My other question related
It's more like, where are the people parking who are going into the building to do the work, and drainage and that kind of thing.
Mm-hmm. Regarding things that are outside, one thing that we've talked about over time is in the event if does site plan review cover everything outside, like whether all buildings and structures, so whether it's a permanent or temporary structures, is that all a part of site plan review?
That's maybe a too broad statement, but I think to the extent that the improvement of the site and the physical configuration and construction implicates those particular interests that are in the bylaw, I think there are 9 of them that are listed, then that more likely than not would be permissible for review.
I don't want to ask any specifics, so I'll just stop there. Does anybody have other questions about this? I want to make sure we have time for the other memo as well.
I just have a question for Dave, just tapping on to what you asked the question about the nature of the use. I see this, oh, so we can't be specific. This is tough. Okay. So it's really tough because if I believe the use by the nature of what they're titling the use to be is something that happens in and outside the building, then that goes against what you're saying, Dave, which is just solely inside the building. By the nature of the way an applicant will say, this is this, and of course, right now you're asking me to do general terms, so I can't give you specific, I can't specifically say the words that I want to say because you're telling me I should not. But by that nature, I would disagree with you that it's only inside, because it takes, on certain cases, I've seen the exterior, maybe they don't house the products on the outside, but there's a component to get to the product from outside to inside, which is just as important as what it goes on inside. Does that make sense, being general?
I think that's really a comment, though, that's related to the use. Maybe an example might be if there's a particular sound associated with a use. That may well be regulated in other ways, but it doesn't really relate to how you are configuring the use or the buildings for the development on the site.
Have
But in
fun.
configuring like the use, you're also taking into consideration what goes on the outside. And in this case, we can't get into specifics, but by the nature of the title of this, this, which I'm not going to say, but because you don't want me to say it, but by the nature of it says that there's use that goes, a tremendous amount of use goes on, or I won't use use, activity goes on outside the building, which correlates on how productive the inside of the building will be. Does that make sense? So if what goes on the outside doesn't
I
work,
under,
you can't get in the inside.
Michelle, I think
right, I,
you're talking about another part of town.
Oh. Okay.
Uh,
Okay.
and I think that comment, I still would see that as something that's related to use as opposed to site development.
Okay.
Okay. Do we have other questions on this one? It sounds like, oh, Amy, go ahead.
Okay, my question's from the same memo, but it's at the end of the memo. And I don't know if it's a question or it's more a statement by how I'm reading it, but it's talk about the special permit with site plan approval.
Sure.
And it goes back and forth. It's kind of like special permit with site plan approval. If I read it in the bylaws, it states that decision criteria for a special permit site plan approval states that it goes back to 703040. But then in the memo, it talks about, well, yes, it states that, but because he could apply for it separately, you could read it the other way too. But I guess the way I follow bylaws is I follow what's written in the bylaw. I don't follow what could be happen, but they didn't apply for that. So I follow the bylaw. And I guess it's not a question. It's just in reading the memo, I found the last section was kind of, well, it tells you to point to this section, but he could have done it either way. So I guess it's not really a question. It was just the way I read it. And I guess it's a statement that I'm saying that if the bylaw states this is what you have to do, then these are the criteria that you follow. So I guess I'm sorry, there's no question, but just a statement.
Carrie, I'm wondering if, maybe you could have Mr. Dineski clarify that, because that was a question that, we talked about yesterday.
Sure.
That the special permit with site plan approval is not a special permit. It's a special permit because they're obtaining a special
Not a
permit.
voter. I'm not a voter. Yeah, I'm town council, and I'm sorry I'm on the phone. Thank you. Sorry about that, folks. I'm going through the gauntlet.
So David, in case you didn't hear, we were just talking again of that instance where we're getting these special permits for site plan approval, which is directing us into one place in our bylaws. But it was pointed out that, well, if you go to this other place, you can see, you can pull apart your application and it's an easier road for your special permit. So there was question about that. On the flip side, there was a letter submitted that made a different argument that said, that's a nonsensical way to look at it, because then you're basically making your special permit criteria. What's the point of it really? Because you're not determining whether adverse effects of the proposed use will not outweigh its beneficial impacts to the town or neighborhood if you're completely ignoring that whole section of what we use on every other special permit. So is there, how do you get to pick your path and make a different path for yourself?
I think this question is distilled to what is the nature of site plan review, and it's an administrative process. It's not its own special permit. It's not described that way in the bylaw. And that sentence that says special permit with site plan review probably could be a little more directly worded, but the rest of the language in the bylaw does not describe what site plan approval is as a special permit. So that's the reason that if you combine your application,
Sorry, that confuses me now because we have a whole section dedicated to a special permit for site plan approval. And it gives us the criteria.
right, and what that says is that the special permit criteria that apply are applicable to the special permit component, and the site plan criteria that apply are applicable to the site plan review or
Yes,
approval
yes.
request.
Okay, so the criteria for a special permit, if you're applying for a site plan, a special permit with site plan approval, then your special permit section of that should apply, shall be set forth in section 703040. But obviously your site approval piece does not.
Right. The 03040 are the special permit provisions that will govern the special permit that's being requested, and 03050 will apply for the site plan piece.
Right, okay, so I get that. So so that's why, because in the past, what has been said by staff is anytime you have a special permit, it kicks off special permit with site plan approval. And the decision criteria is for a special permit, the special permit component, we look at 703040. And then site plan, we obviously look at site plan approval.
Well, I think,
Yeah, I think we're getting to the same endpoint, but I'm going to let Kathy
Yeah.
jump in here.
well, yeah, I was just going to say, I think a couple of things are being combined, which are making it, I think, more confusing. But again, for when someone applies and checks off on the application form, special permit with site plan approval, they are checking that off because they are seeking a special permit that is required elsewhere in the zoning bylaw.
Mhm.
So if it's a special permit from groundwater, then the special permit criteria from the groundwater bylaw applies.
But
If
it's not saying that here. It's giving me that other section is what I keep getting. So
Well,
Bob, I have a question for you. When you write on your zoning interpretation sheet, you're the one who writes special permit with site plan approval. What kicks that off in your mind? Because you're so close to the bylaws in general, and you're on mute, by the way, so I won't be able to hear you.
Again, when somebody comes to me with an idea, I don't go into the amount of detail that the boards go into in terms of what they're going to do for use or whatever. I try to take what they're saying, pigeonhole it into one of the uses, and if it needs a special permit, according to the charts, that's what it needs. And then I go back to the beginning of the book, and it says any special permit, okay, requires a special permit with site plan approval in addition to the regular special permit. Okay, and that's, what is it, 77050, I think? I don't
Okay.
have my book in front of me.
So that's how you interpret it when you
Yeah.
fill out those forms.
Yeah.
Okay.
But I think getting back to the special permit criteria, in each section, whether you look at, and I mean, we had discussed this on our phone call yesterday with Carrie and I and town council, is that in the groundwater bylaw itself, which is an overlay district, in each one of the overlay districts, it has its own special permit
Oh,
criteria,
of course, right.
which is what needs, whoever is the special permit granting authority. Sometimes it's the planning board, sometimes it's the zoning board of appeals. That's the special permit criteria you have to conform to, or the applicant has to, make sure that they answer those. And the board has to review it to make sure that the applicant meets that special permit criteria. And
Yeah.
then if you're applying in general, there are many uses in the use table that require a special permit that's not associated with groundwater, not associated
Oh,
with,
right.
major commercial overlay, then absolutely, then those are the special permit criteria that's written in the state statute that's reflected in the zoning bylaw.
Got it. Okay, Bob, did you have something else to add? It looks like you were looking at something.
No, I just, actually, one night, I dug up my book.
Did you want to, you have, if you want to add something, you can.
No, I mean, it's, basically what I've always done is if, like Kathy says, if it's in the chart, needs a site plan, a special permit. If it's in groundwater, it needs a special permit, whatever. And then I go back up to 703-050, paragraph 2, and it says a special permit with site plan approval shall be required for any use requiring a special permit.
Yeah,
Okay.
and that's
which-
consistent, yeah.
So basically it's a special permit and a special permit with site plan approval.
Gotcha. David, I have a quick question because I know you can only stay till 5:45 and I do want to give board members a chance. You sent a second memo today where you took a closer look at the history and you indicated that we've done it a certain way for a long time. And it wouldn't be unreasonable for us to continue to do it the same way that we've always done it.
Well, there's a basis for it, but there's a countervailing argument as well. That's why I gave sort of two collections, if you will, of principles of interpreting statutes. One relates to practice and one relates to what's in the wording of the statute or the bylaw that you're looking at. And that latter one would typically be the one that is ultimately a basis for decision. One of the sort of threshold principles is you start with the words in front of you. But what I didn't do because I wasn't able to, and I don't know if we could at all, obviously I looked at some decisions that we were able to collect in a short period of time, but obviously not all of them. So I wouldn't want to say that everything has been done X way for however many years, just because I'm not sure any of us is really able to say that right now.
Okay, do any board members have questions? I don't want to, we only have a few minutes, so I want to give everyone the chance. Millie, do you have additional questions?
No, not yet. I'm really just trying to grasp all of this.
Amy? Amy, I can't hear you. Are you on
Okay.
mute?
I guess one of my questions for Dave Daneski was, this is an application. Well, there are some big applications in front of us, and we're going into this, with an unbiased decision to hear both sides. And I was wondering why your memos actually answered one attorney's the way he was reading it, but didn't actually ask, and it didn't answer any of the others. Like we got 5 attorney letters. And I know there was one attorney mentioned in one of the letters, but then there were attorneys for the other side. And I was just wondering why we talked about one attorney's letter and either agreed or disagreed with it, but didn't touch on the other attorneys.
I think that was simply because it was anecdotal. I did read all the reference them all because I didn't think that I necessarily needed to, but I certainly did look at them all.
Amy, other questions?
And one thing that I didn't want, if there were something that were succinctly stated, and this would be a general practice anyway, that someone else may have said, it's sometimes shorter to reference that, but I wasn't doing this as an exercise of looking at everything that each attorney might have said and considering that I had to answer all of those. I don't think that everything that has been said necessarily needs to be evaluated or considered in order to address the questions, the more global questions that have been presented. And just as a quick example, there's a reference in one of the letters to language about unless otherwise provided. And I think that's in the special permit language. And there's a statement regarding that having reference to anywhere else in the bylaw. But I don't think any of us has enough historical information at present to know whether that's a correct interpretation. And so I don't address that. I don't think it needs to be addressed for the particular question here, but I also think it would be premature or a decision on an incomplete record to respond to that.
Amy, is that it from you?
Yeah, I guess.
Okay, Michelle, anything from you?
No, I just wanted to clarify that I was reading Dave's letter from September 14th, and it is on 2 different areas of town. You may have been talking about one area, but Kathy, I was talking about the other area. So I do think that it was the similarities to what Carrie was saying about the use, whether the use happens outside the building. So I know it was a second area of town, but this letter specifically states both applications, which are on 2 separate areas of town. So.
Just, I did mention, I believe, the 2 properties because it was in the context of those applications that the question arose, and that was the purpose of doing that. So the letter is intended to state a general principle, but I just gave a little context of how the question came up.
Okay, and then Anthony, oh, Michelle, I'm sorry, did you have another question?
Yeah, I'm all set.
Okay, Anthony, do you have another question?
I don't.
Okay, so it's the one thing I just want to clarify, I had sent over a list of different decisions where we showed consistency in doing it, of looking at our applications where if there's a special permit for site plan approval, we do the specific criteria and then we do the general criteria. So I just, again, want to make sure that if we've been doing it that way, if I've pulled decisions since 2005 that have that done, I just want to make sure that, going into these hearings, we need to know, okay, we've been doing it this way since 2005. If that's been lawful and there hasn't been any sort of issue or appeal or complaint, what does it mean if we change course suddenly with one application to say, oh, well, we're going to not do it that way anymore. We've decided to go a different direction. Is there some,
Well,
that looks strange?
It's always the case that if there is, and again, speaking generally, an approach that has historically been followed, that doesn't necessarily mean that that's the right approach. And I'm not commenting on the particulars here. I'm just giving general
Right.
observation. And just for clarification, the issue is the criteria for a special permit in that groundwater overlay district. And that was the distinction point or the issue that was raised in the second letter. And I gave, again, the principles that could be applied or would be applied to the issue or the history component
Yes,
versus the language component.
right.
And unfortunately, I do have to cut
Okay.
out at this point, but I think at the end, the last paragraph probably does indicate where I think the probably stronger argument is.
But it was kind of confusing because you said you could do it this way, technically you could do it this way, technically you can do it this way. So-
Right, but in preceding, there's a reference to how I think a court would probably construe it, and then I did make that point again. I'm certainly glad if there are follow-up questions,
Yeah.
if they want to be posed, I can certainly do something in addition.
Okay, all right, great. Thank you for joining us.
And just
Okay,
so that
you're
all the,
welcome.
Oh, go ahead, Kathy.
bye, Dave.
Thanks,
And
bye.
just so that everybody knows, if you want Mr. Dineski to be present at your next meeting, October 6th, he is available.
Okay,
And can I just clarify on the last statement that he made? He said it's his last paragraph on page 4 of his letter dated September 14th, correct?
No, he was just speaking to the September 15th letter.
Okay,
do you have that one, Michelle?
I'm going to look for that one right now.
So he's saying that, he says the reviewing courts should give deference to administrative interpretations of a statute. Interpretations of agency charged with primary responsibility of administrating statute entitled to substantial deference. So if we've been doing it this way all along, that we should get some sort of deference, is how I'm reading it. Can these be posted publicly, Kathy, so everyone can?
Yes, yep,
Okay,
yep,
yep.
we can put them up on the website, you know, under the, well, I'll figure out where to put them, but probably just under meeting materials in general.
So if we've been doing it all along, that could be evidence of a basis for the special permit granting authority to apply both the overlay district criteria and general permit and general special permit criteria. But then he also says, however, then you could see, look at your bylaw language, and that could be the case. So it's just, so maybe that's something we need to follow up on, because it's too, maybe that's just a legal thing, but that sounds like both sides work. So I just wanna, we'll have to clarify that. And it sounds like, you know, when Bob is doing something a certain way, there must be some sort of deference to that. If we're, you know, if he's looking at the bylaws and interpreting special permit, he's the one selecting that based on the bylaws. What does that mean in terms of, I mean, that's a question for Dave too. So I don't know, what's the best format to do follow-up questions for Dave? Is that something we do here?
Yeah,
Or-
you need, yep, you need to do it, you know, in public at a meeting. And you know, whether you want to do it, I was just looking at the time, you know, whether you wanted to do it now, maybe while it's fresh, or, you know, do it under old and new business.
Okay. Does anybody have any immediate questions? We have 10, we can't start our hearings until 6 o'clock anyway. Anthony?
Yeah, so just a quick question for Kathy is, I assume there's a reason why, but I just wanted to ask the question anyways, why we can't do this in an executive session, just so we can ask real questions?
There isn't, I had checked with town council about even having this discussion that you just had in
Yep.
executive session, and it doesn't meet any of the criteria for executive session because you don't have, you as a planning board do not have any pending litigation.
Okay.
Other questions?
Kathy, can I just ask something?
Sure.
The last time we were in executive session with him, I thought we discussed the soccer fields and the Dover Amendment. Were we in litigation with them?
No, you, on that wasn't, I believe what you had questions for, and I don't have my old agendas in front of me, Michelle. I think you had an executive session about 425, and it was regarding the appeal that is before the zoning board of appeals, and how did that interact or influence or, you know, play into your decision making for 425.
Okay.
Did you have a question, a follow-up question, Michelle, that you want to put forward? And some questions may come up as we go through.
You mean for Dave? We're talking about Dave right
Yeah,
now?
any follow-up questions you have?
No, I've got his memo that he just talked about and he says he summarizes it. I have it right up on the screen right now. I'm just looking at it. But I do have questions about all of those. I think it was at 8 or 9 decisions that I'm assuming he analyzed, and then he wrote this feedback on looking
Yeah,
at
and you,
one of those decisions, right?
yeah, you have, as a planning board, I had originally sent to you in August
Right.
all of the decisions that the board had written pertaining to Bartlett Street. And then after Carrie and I met with town council yesterday, we discussed a few other decisions that the planning board has issued that were site plans and also groundwater special permits. And so those were provided to, I think there was 4 or 5, those were provided to town council last night. And I can forward you those decisions. So that's where I believe, you know, that he had, you know, where he's saying that the decisions have been done both ways.
Okay.
But the ones that he looked at, the decisions were only done one way. The ones that were submitted to him, there was only one way for all of those.
The most of the Bartlett Street ones, but the other ones that I provided to him after our meeting, just were other, random site plan decisions from the planning board.
Mhm.
And so some of those contained very little findings. Some of those, um, like I said, were a site plan approval and a special permit for groundwater, but the criteria wasn't listed, in the decision.
Could you conclude me on those emails and
Oh
actually
yeah.
share
Oh
those
yeah.
with me?
I'll
Okay.
forward I'll forward those. Like I said, I think it was 4 additional decisions that I gave him. Everyone else has, I mean, I can send them again too, but everyone else has the other decisions from the end of, it was like mid to end of August that I sent those out to the
Yeah.
planning board after your
Yeah.
August meeting. No, it was in preparation for your August 18th meeting.
Okay. Let's see. Okay, does anyone, sorry, did I skip you, Anthony? Did you have follow-up questions?
I did not.
Okay. Michelle, you will have some, but not right now.
Right. Kathy, you're going to send us those 4 others that you talked to legal counsel about, right?
Yes. Yep.
And then we've got the others up from 2005 to current. Okay.
Yeah, I think there was 5 for the same area and 1 was from 2020, like our most recent one that we just did.
Yeah.
Amy, did you have additional follow-up questions?
No, but I agree. This was very difficult because, we got his letter an hour or 2 ago. Now that we have to discuss at 5 o'clock, and we're not allowed to state any specifics. So I just want to actually announce my frustration. I think it was very difficult.
Well, it's not that you're, no one's not allowing you to do it. We have to follow open meeting law.
Right. But even the memo for him that we were supposed to discuss, we just got 2 hours ago. So, I mean, it was a lot to take in, sort through, and then have questions that you had to state without being specific. I guess that's all I'm trying to say. It was a lot more difficult than I expected it was going to be to have a discussion with him.
Okay, it looks like we have a couple minutes here. I guess my follow-up would be, based on how we've been doing things and based on if you were to look at the instructions that applicants are given by staff, and if you look at the way Bob interprets it and writes on his sheets what they need to apply for, we keep saying to people, this is actually a special permit for site plan approval, or Bob will check it off and say, this is where I looked, I'm going to check, this is a special permit for site plan approval. So if we've been doing it that way, not just what we write in our decisions, but our actual process also supports that. I guess I would just want him to kind of look at like our process from start to finish, like when the application comes in, how we advise them on what they need to ask for, how they craft their applications, what sections they're referred to, and then all the way through to the decisions. It's not just the, looking at decisions in a vacuum, it's our whole process supports this same thing over and over again. So I just I'd be curious to know from him, based on what we've been doing from process to decision, have we been doing it unlawfully since 2005? I doubt that. So, how have we come this far doing it this way for that long? I guess I'd want to know.
Well, I mean, just, this isn't answering for town council by any means, but I mean, I think that the town adopted site plan in the late 80s. I believe it came out of the first comprehensive master plan that the town did. And then there was some changes to it in 2009, which was the last major overhaul of the whole zoning bylaw. But but again, and he made a reference, Mr. Dineski made a reference that, perhaps it's not, worded clearly enough, for some people where it says, special permit with site plan approval. And not that that's the quick, easy fix here, but that's in turn then how all our forms are written.
Oh, yeah. Well, but I mean, to his earlier thing about if we need to tighten up our bylaws, that's one thing. But that doesn't mean we have to like all of a sudden flip we're still working within what our bylaws say. It's not like we've been running rogue since at least 2005, which is the original application on my list the decision that I submitted. So if we've been working within our bylaws for that long, and there's nothing, maybe we need to tighten up our bylaws to make it clear to people, but that doesn't mean that we've been operating in a unlawful way, I don't think.
No, yeah, I agree. I
Yeah.
agree.
The only thing is, my only other follow-up would be, he had mentioned, the town council mentioned on our conversation, he didn't have, he didn't have enough time to, fully look at the letter from Attorney Timon. I'm sorry, not to be specific, but I would be curious to have a second glance at, those comments about what happens if we do have that, that split where you get to pick a path and one path is this way and one path that way. Is it, he makes a comment that that's nonsensical. So I want to figure out, maybe not just for this hearing, but what do we need to do to our bylaws to not have that be the case where we're not making one section of the bylaws is negating another section or making it unclear for applicants, for us, everybody's gonna, if we're all running in different directions, we're never gonna make this an easy process for anybody. So that would be the other piece for me.
So Carrie, just to repeat that, so you have a general question, which obviously is very comprehensive, but clarifying with town council if the process that, from how something is determined in the town hall to be, which path that it needs to take. So from the very beginning of the process to the decision path that the board takes, has the town been doing that correctly based on the bylaw?
Right.
Is that fair to
yeah,
say?
According to the way we've been doing it, I guess correctly. Although I don't mean to assume that we're going to find out it's incorrect.
Well, okay. Well, just based that you've been doing it, or that it's been done based on the bylaw and or practice.
Yes.
Okay. And then the second question is asking him to review and comment specifically on Attorney Tineman's letters.
Yeah, maybe just take a little closer look at it because we really, to Amy's point, we didn't get a whole lot of analysis on that. It would just be interesting, specifically just about what does it mean if our bylaw, if we're allowing applicants to pick different paths, what does that mean? Does that make our special permit criteria nonsensical? Does it make it, what's the point of it? I guess it sounds like what was being said here, but it would be helpful to understand from town council's point of view, any sort of impact on our bylaws.
Okay, so those are the two questions so far.
Okay, all right, we are at 6 o'clock. So we can get back to that after. Yep, it's 6:02. So 6:02 in the evening, we are moving on to the continued public hearing for 425 Whitney Street, special permit site plan approval and special permit for groundwater protection overlay district. The applicant is Staris AST, engineer VHB, date filed September 17, 2019, and decision due 90 days from close of hearing. So I need to bring in
Carrie, can I just ask you a question before we do that? Do you want to, just because I just took a look at the attendees and a lot of people, I believe their names are associated with Zero Bartlett. Did you want to take care of that Zero Bartlett and then those people can decide whether they want to stay on the meeting or not?
Okay, sure.
Just a suggestion.
Okay, so that's fine with me. Is that okay with the rest of the board?
Yeah.
Okay. So scratch that. We are going on to the continued public hearing for Zero Bartlett Street special permit for groundwater protection overlay district bylaw and special permit site plan approval for Gutierrez Company, engineer Allen and Majors, date filed September 24th, 2019, decision due 90 days from close of hearing. So why don't we open that hearing? And we have, Kathy, do you want to share the letter that's been submitted? Or do you have it offhand? or
Yeah,
can
I
pull it up?
do. I have both letters that Attorney Mark Donahue submitted 2 letters to the board this afternoon. One asking or requesting a continuance for both the site plan approval and special permit per groundwater bylaw hearing, and also the discussion that is ongoing about the preliminary subdivision for Bartlett Street. So he's asked both of those to be continued to the next available planning board meeting. And then along with that, if the board, approves of continuing those to October 6th, they are granting an extension of time for the preliminary subdivision to October 30th, 2020.
Okay, so I have the preliminary subdivision as a separate agenda item, so do they need to be separate entities?
Oh, sure. Yes. Yeah, you can vote on those separately. Yeah.
Okay. So, Kathy, you mentioned hearing wise on October 6th, we only have one hearing scheduled.
Right. For right now that you have a new application in that that everybody should have received in the mail. It's for 399 Hudson Street, and it's a duplex, a special permit duplex application. So your hearing, I've scheduled the planning board hearing for October 6th at 6 o'clock. I just continue to schedule all of them for the same time.
Okay.
So that's the one, and there won't be anything new that comes in between now, and October 6th that would be heard on October 6th.
Okay. So our options are either October 6th or the 20th.
For Bartlett Street, yes.
Okay.
Those are your 2 meetings in October.
Okay. Does the board have a preference?
October 6th is fine for me.
And again, town council is available to be present
Oh,
for
that's
that
true. That's
meeting.
Okay. Yes, so why don't would someone like to make a motion to continue the public hearing for 0 Bartlett Street special permit per groundwater protection overlay district bylaw and special permit site plan approval to October 6th at 6 p.m.?
So moved.
Okay, second?
Second.
Okay, moved and seconded. Any further discussion? Okay, so let's see, I will do a roll call. Millie,
Aye.
Amy,
Aye.
Anthony,
Aye.
Michelle,
Aye.
and carries an aye. So that hearing will be continued to October 6th at 6 p.m. So I'm going to move along to the continued discussion regarding preliminary subdivision for 0 Bartlett Street. So we've heard the letter of requesting an extension. That's different than the letter you just read, right?
Well, part of the letter where he's requesting an extension of the public hearing for the site plan, he's also requesting an extension of the public discussion because a preliminary plan doesn't get a public hearing. It's just we notify the abutters, but it's so it's a discussion. So he's asked to move that to your next meeting also, and then along with that, sent a separate letter saying that they agree to extend the time within which to make the decision.
Okay. So this extension is granted until October 30th.
Correct.
Oh, Amy.
I just had a question. I know he's asking for continuance, but when we received the Allen and Major letter, there were no impacts due to no tenant. It lacked a lot of detail. And then on August 18th, we got a letter from the town engineer stating there was a lot of information missing and concern from the DPW. I'm just concerned because this is a preliminary subdivision, and I'm concerned that at some point we're going to risk automatic approval. So I almost want to make a motion that we deny it, and then when they're ready, they can come back. Like it keeps getting bumped and bumped, but there really wasn't any information and no information has come in. Like I was ready to discuss it tonight again, but there's no new information coming in. And because it's preliminary and we just had a class on it recently and there's a risk for automatic approval, I want to make a motion that we deny it, and when they're ready, they come back. I feel there's a risk to push it off to the end of October.
Well, they've granted you an extension. I mean,
Right.
this is the second extension that they've granted you. The first one was to the end of this week, September 18th. And then the letter that came in today is extending it to October 30th.
Right, but is there any harm in just,
So, wait, I just want to make sure, Amy, are you just asking, you're not making a motion, you're saying you're considering a motion?
I am considering it, but
Okay, I just want to make sure.
I mean, I
You
could
made a
make
motion, okay.
I
all right.
just want to know what the risks are associated with it. I am considering making the motion because I feel there's a lot of risk more on our end where it's just a preliminary subdivision. They could just come back. They could resubmit it when they have all their materials. So
So
I don't know if,
sorry, do we have any new material? We have no new materials.
no, not that I've received. And I checked online today to see if any more new materials were coming in. So I don't know what other members think about it. Do you feel it's a risk? Or, you know, that's just what I foresee happening. You know, eventually it's going to get approved because we keep bumping it. We're not getting any new material. One all of a sudden it's going to come to the 30th and maybe that meeting is canceled or somebody forgets and all of a sudden it's approved. So why not just make a motion, deny it, and then have them come back when they're ready?
With a new preliminary?
Yeah. Anybody else feel the same risk, or does anybody else see or should I just make the motion and see what happens and discuss it then?
I have a question for Kathy. Considering this is preliminary, I mean, if it were to just automatically pass, would it really even matter considering I think they would still have to go through the whole approval process, wouldn't they?
Right.
I mean, the application process.
Doesn't that change the timeline? Once it's approved, like then you're on a different timeline.
Well,
Maybe.
with an industrial subdivision, you have to submit a preliminary subdivision. That's state law. With a residential subdivision, you don't have to submit a preliminary. You can just go right to a definitive subdivision. And, you know, granted, we don't see subdivisions a lot. And I'm not even sure. I think this one might be the first one this board as in this composition has seen. But with a preliminary subdivision, the board, you know, it's up to each individual board, but the state statute allows you to, you know, hold an informal meeting if you want or not. It allows you to approve the preliminary subdivision with or without modifications. It allows you to disapprove the subdivision, but you have to have a detailed statement of reasons for that action. And then again, the preliminary, you know, gets followed by a definitive. Carrie, I see that the attorney has his hand up for the.
That's fine. Hold on a minute.
Okay.
We're not discussing the application. We're just discussing our process. So
But
I
I mean,
have that if an extension's not granted, we could move to deny. So what I want to make sure is that, I'm just looking up from the timeline.
so that what you have with a preliminary is when from the date that the preliminary subdivision is submitted, whether it's a residential or an industrial or commercial, state law gives the planning board 45 days to act on that preliminary plan, unless otherwise, you know, mutually extended by the board and the applicant. And that is what the applicant, you know, has done. This is the second, you know, extension that they have provided.
So based
So,
on town's comments, do they then technically would have to submit a new one anyway? Because it looks like there are some issues that came from town. So, or should we be expecting a revised one or?
that's what I would be anticipating, is that, that they would take the comments that they've received, any applicant, the comments that they've received from the town and, and address those, in whichever way they seem fit, I mean,
Right, so, yeah. So why wouldn't we, so the preliminary as it is, isn't getting approved because it has a lot of problems with it and now they need to go back and fix those problems. So are we just leaving a timeline, a never ending timeline on something that has a serious timeline?
No, I don't think that, I mean, I don't know. I guess I just don't see the downside of when you're working with any applicant, the purpose, of submitting a preliminary is basically to work out the bugs before
Oh,
you,
okay.
you
Well,
know,
what was the
before
reason
you get
given?
to, I'm sorry, what?
What was the reason given? Was it to do that or, hold on, I'm trying to pull up. What did the letter say again? Was there a reason
The,
given?
um, I can just read the whole letter. It is our understanding that the planning board is meeting with town council in the course of the public meeting on September 15th in order
Oh,
to
no, not that one. The one where it's the granted, so extension.
Oh, this correspondence will confirm the agreement of the applicant, the Gutierrez Company, to continue the date for the planning board to take action with regard to the preliminary subdivision plans submitted by the applicant for 0 Bartlett Street, currently pending before the board to and including October 30th, 2020.
Okay, so no reason given why.
And sometimes I think like we've been hit with 2 other lawyers and they say, we put in this application in July and now it's January or February and you haven't replied to us or we haven't come to a decision. Now I think we have to decide on this quickly because we submitted this in July. And I'm not saying that this applicant won't, but that's always what comes back to haunt us. They come back and even though we're continuing because the applicant has so asked, in the end, they hold it against us and say, well, now this has been open for 6 months and we're looking for a decision tonight. And I'm not saying that they will or they won't, but all I'm saying is this is a preliminary and it had no information. It had no tenant. There were issues from Fred. There were issues from the DPW. I say we just deny it, make a motion to deny it, and then start fresh when they do have the information to come forward with.
Well, first it's a motion to not grant the extension, then it would move to denial. There's nothing really to.
Right.
Right.
But it's up to what the other board members think. And if you want, you can, we could talk to the applicant. I just don't see the harm in it, but I do see the risk that at one point it may not get extended and then all of a sudden it's an automatic approval, which we don't have with a lot of things. And after extending it for the applicant, we could have something approved that had no information whatsoever.
Okay. Any comments?
Carrie,
Yes.
it really doesn't, as Kathy indicated, it really doesn't matter one way or the other whether it gets approved or disapproved. But where the applicant went to the trouble of offering you an extension so that they could supposedly submit more information at your next meeting, it seems like they want to proceed and satisfy the board with whatever the board needs to approve the project. It
Oh,
seems
okay.
like
I
it'd be
didn't know that they had submitted that because I don't think we ever opened the
No.
hearing at all.
no, well, there is no hearing. It's just a
Oh, sorry.
discussion.
I keep saying hearing. I'm sorry.
That's
I don't
right.
think-
But
Yep.
where they're extending the timeline for you to make a decision, it seems like that they're working on something and they're just not ready yet. Seems prudent that you would at least give them the opportunity to come back at the next meeting. And if you don't get anything by then, that's gives you enough to make a decision, you could deny it at that point. But it
But I
seems
don't
like
think-
since they went to the bother of asking to offering an extension, seems like the reasonable thing to do would be to grant it.
So I'm sorry, I don't have that same reason. That's why I'm asking, like, what's the reason? What was given the first time around? Was it because to provide more information or I'm sorry, I don't have that.
I'd have to check my notes, but it may have been that I gave him the letter the night of the meeting
Oh,
or the
okay,
day before.
okay.
The
I see.
comments that he got from staff came not too long before the meeting.
And what is the previous letter, written request? Do we have that on file?
Um,
Sorry, I'm looking. The one that they requested the first time.
So what was his reason for wanting to extend it this time? Was it, Because-
There wasn't a reason, but we never opened I'm sorry, I'm calling it a hearing. We never opened it to start, so there was never any information given for them, aside from your memo. The board never said, you need to provide this to us. So I just don't have that written somewhere. That's what I'm looking for, that original letter. If anybody, Kathy or Fred, do you have that?
I'm looking to see if I have it in my
Oh,
file.
sure, thanks.
but for this time, I just wanted to see if it was something they thought that we held them up on, or if they even indicated because we're moving one, we're gonna move the other. Does
Yeah,
that
they're
matter?
kind of, yeah, I don't, hold on, let me pull up the other one.
I mean, I'm looking through the file, but I mean, meanwhile, the applicant is here in the meeting.
Yeah, I see that. I'm just looking for, I'd like to understand what the reasons are for asking for this. And I don't have a copy of the first one. We're saying it's to provide additional information. You know, we've had a complaint from them that we're not moving their stuff fast enough. There was quite a strong letter drafted to us about continuing them month after month, and they want timeliness. And now we're in a circle of continuances, to Amy's point. And, you know, is this going to equate to the same strongly worded letter that we're not moving fast enough here? So I'm just curious, what is the reason from the first time around? Does anybody have that?
No, I can't find it just yet, but I
Right.
mean, given that they're the ones requesting the continuance.
Right, but I guess I'm just curious, so that I don't have it in front of me. Are they requesting because we aren't prepared, or because they're not prepared?
I think, well, again, I mean, the letter from today is, it talks about that the correspondence, this is the correspondence from town council. This correspondence shall serve as a request of the Gutierrez Company that the continued public hearing for 0 Bartlett Street special permit per groundwater overlay bylaw and site plan approval, together with the continued discussion regarding the preliminary subdivision for 0 Bartlett Street, be continued to the next available planning board meeting.
Okay, and then from the first one, the first written one, what is that one?
No, that's what we're looking for.
And how would it really affect? I mean, if it gets denied and then resubmitted, since it's only preliminary, it shouldn't even, it would just start the date fresh of the submittal. Since we don't have enough information to go on.
With all due respect to the board, you folks seem to be looking for an answer or to a question that can easily be supplied by the guy who has his hand up in the waiting room.
Oh, I know, and I will plan to include him. I'm curious. I just want to see this reason.
Well, he can tell you the reasons.
I just want to see the written request that came the first time is what I'm looking for. I don't,
Sure.
that's all I'm looking for. There was a letter that came to us that made a giant deal out of delays and also making sure that the applications were viewed as very separate entities. And now they're combined and asking for continuances where I don't want to fall into the trap of where we're combining the two again and we're continuing them. I'm just curious to see what was written the first time around. I don't think I even have that.
No, I think he made the statement at our meeting and then he said he was gonna send Kathy email with a date the next day.
Oh,
Which he has done, but that's what I'm looking for. But you know, we haven't had Debbie for a while, so these aren't necessarily in order.
I mean, it does sort of read like he is saying that they're wanting to postpone it because they just got a lot of information from us yesterday.
Which one? Oh, you have it, Millie?
I have the letter from today.
Oh, okay.
Says, in light of the board only, I don't have the first one, but in light of the board only receiving that information immediately prior to the scheduled public hearing on the above referenced applications, and further, given the plethora of information that has been provided to us just yesterday and today from other sources, this correspondence shall serve as the request to extend.
Yeah.
So it does
I
look like,
I have an email. This is for one of the continuances. This pertains to the last meeting, which was going to be held on September 1st, which
Yeah.
was the primary.
yeah,
And so this is a letter, an email from Mr. Israel Lopez from the Gutierrez Company. I understand that the planning board meeting scheduled for this evening, September 1st, cannot take place due to the statewide election. I therefore request that the hearings for the special permit and subdivision of the above referenced site be continued to 6 p.m. on September 15th, which I understand is the next scheduled planning board meeting.
Okay. And the one before that, I think it was.
Yep, that's the one we're still
But
looking
the
for.
the thing that I'm wondering about is the memo from KP Law was only about Zero Bartlett, and the two are separate entities, as we've been told. So it wasn't information about the preliminary at all in this one.
I mean, my guess, Carrie, and again, you know, Mark and Mr. Donahue can answer this, but my guess is that because it's the same attorney, the same applicant, the same engineer, they just want to bring everybody out, you know, at one time.
Okay. All
That's
right. So do we
that's my
not-
guess, but that's I'm
Okay.
not the applicant.
Do we have, so we don't have it from the first time?
Well, not that I can find, but I'm sure it's either in the, you know, either still online or it just hasn't been filed in the folder.
Okay. All right. So let's see. Why don't I get Mark on the line then? Hold on a second. Mark, can you hear us? Oh, we
Yes,
can't
I
hear-
can.
Oh,
Can you
hello.
hear me?
Yeah, so we're just talking about your request for continuance, and I'm just curious if there's a specific reason. Are you sending a
Sure.
revised?
Sure. Let me first try to refresh the recollection of the board how this came about. You scheduled the public meeting, not
Mhm.
hearing, with regard to the preliminary plan, and made it the same evening as the hearing on the special permits and the site plan approval. That was August 18th.
Yep.
By my notes, the meeting with regard to the special permit and site plan ended with a motion to continue to September 1st at approximately 9:18, and you had a hard stop at 9:30 for your licensing, and you had some other issues.
Okay.
So what we said then verbally was that we would be glad to continue the public hearing on the public meeting, pardon me, with regard to the preliminary plan. So it would be simultaneous with the continuation of the special permit, which was then September 1st. There was a concern expressed about the 45-day period, and we continued not to September 1st, but the letter we gave, which confirmed what we said on August 18th, extended that period of time out to August 18th to provide for the type of circumstance that actually arose, which is the hearing didn't occur and the board wouldn't be under any particular pressure.
Okay.
So this evening, we made a request for the primary issue, the special permit of the site plan, to continue for the reasons stated in the letter, so that both you and we would have time to digest the discussion with town council. And we've received an awful lot of information as recently as this afternoon that we need to digest.
Okay.
And asked for the next available meeting, and that's the board's convenience, and asked that that also be simultaneous with the preliminary plan. And that's simply as a matter of expediency, because as Kathy indicated, the development team needs to show up for that and do it all at the same time. I
Okay.
extended the date. I extended the date for the board to make a decision with regard to the preliminary plan for the month of October in its entirety, because I didn't know the board's schedule and when you would desire to have this meeting heard during the month of October. We do have Mr. Litchfield's letter. We have frankly been focused more on the special permit and site plan, but we can certainly be in a position to discuss that on October 6th. And to the extent information is available in advance, we'll certainly provide it to the board so that they'll have time to digest that in addition and address that at the time.
Okay. So you are resubmitting, are you submitting a new, something different, a revised version, or you don't know that yet?
No, we are not.
Okay.
We are responding to the comments of Mr. Litchfield, which I do not presently have in front of me,
That's
so I'm not in
okay.
a position to discuss them.
That's fine. Okay, so nothing revised is coming, but you want to address those questions.
Response to comments is coming.
Response to comments is coming. And were you able to get those memos that were sent from council so that you have them too?
Yes, we now have them.
Okay, so you have those too. Okay, great. Okay, so thank you for clarifying that. So the reason is really just, well, just out of the way that things have kind of played out. So what I don't want to do is, in the past, you've expressed concerns about continuing and concerns about us combining those two together. So are those still concerns, or do you view this as a separate issue?
Well, I think the record is abundantly clear that this request for continuance is our request for continuance for the reasons stated in the letter. So we certainly have no objection to the board granting our request to the board's most convenient meeting in the future.
Okay, so then I guess I'm not, so the exact reason then that you want to continue is just, you want time to prepare comments?
Well, continue. Is your question focused on this preliminary plan
Yeah.
alone or
Just
everything?
preliminary, just preliminary.
On the preliminary, it's in order to be able to respond to the comments and to have the development team appear when all matters relative to the property are also being heard by the board.
Okay, great. Thank you for, does anyone have any questions?
Well, does he think they'll be prepared for October 6th, or should it be the second meeting in October?
We'll be prepared for the 6th.
Okay, any other questions?
No.
Okay. Okay, great, thanks. That was really helpful.
Glad to help.
Okay. Okay, so with that in mind, did you find that letter, Kathy, by any chance? Do we have that on file? No, but it's somewhere. We know it's written somewhere.
Yeah, I know there's an email.
Okay, so they're not really preparing a new plan. They're just preparing comments. And let me find those comments actually. So I don't know, Amy, does that change what you're
Yeah,
thinking?
that's
Or-
fine. As long as, when I saw it's October 30th, and I just wanted to make sure it doesn't just keep getting bumped and bumped and bumped until we finally, all of a sudden we have a glitch and it's automatically approved. So if he's coming back on October 6th, I can make a motion if you want. I'll make a motion to continue.
Okay.
Everybody else agrees?
Yeah,
Well, if
maybe
make
you
a
have to
motion,
do the
then you-
time and date.
Oh, I know. I just want
Oh.
to hear if anybody else has any comments before I do it.
Well, if you are making a motion, I just need a second and then we can open discussion. So are you
Okay.
making a motion?
Sure, I'll make a motion to continue it, the preliminary subdivision for 0 Bartlett Street for October 6th.
At 6 p.m.?
At 6, if that's
Okay.
when we're starting.
A second.
Okay, so now we have a motion and a second. Any further discussion? Anthony or Michelle, anything from you?
No.
Nope. Okay. Okay, so then we have a motion to continue the preliminary subdivision for 0 Bartlett to October 6th at 6 p.m. I'll take a roll call on that. Millie,
Aye.
Amy,
Aye.
Anthony,
Aye.
Michelle,
Aye.
and Carrie's an aye. Okay, so that will be continued until then. So we now have both hearings for 0 Bartlett to October 6th at 6 p.m. Is that what you have, Kathy, in your records? Okay. Okay, great. Moving on, we are going back to the continued public hearing for 425 Whitney Street, special permit site plan approval and special permit for groundwater protection overlay district. So now I need my list of who to bring on. Let's see. Of course, Kathy, now I can't find, oh, there it is. I see it now. Lots of people. Okay, so I'm bringing on for Steris. I have Ken. Are you there, Ken? No. Oh, I see Steven. Let's see, yeah, Rich is on this one. Okay. Nancy. I don't see. Keith. I don't see. David Jackson. Oh, I don't see a lot of. Let's see. Is there anyone else? Do you want to raise your hand if you're also on the STARS team and I didn't pull you over? I don't see a lot of these.
Hey, Carrie, I think Mike Corelli is part of that team as well. M. Corelli.
Do you see him? Oh, yeah, there we go. There's Mike. Anybody else? Okay.
Rich Whitehouse.
Yep, he's on.
Okay.
So I have Rich, Mike, Steven, that's it. Does there anybody else? Just raise your hand if you're on this team and you want to join. Okay, looks like we're good. Okay, so we are looking at tonight. We were originally going to look at the RFQ process, but we've since received a letter from Steris. Steven, you're on the line there.
Yes, good evening.
Yep, hello. So we received your letter with some concerns that you outlined. Just gonna shift gears here. Okay, so do you want to speak to your letter at all, or?
Sure. Thank you and good evening, everybody. My letter from August 18th was focused on the use of the property, as the planning board knows. And I think every appearance before this board, I've been citing or referencing that site plan approval is not a review of the allowed use or a regulation of the allowed use. And, you know, despite that, Steris has been very forthcoming and willing to field questions and provide answers about the use. But, you know, we're a year on and they own this property. It's an allowed use in the industrial zoning district with an existing building. They were hoping to get underway to get the economic benefit of having paid quite a bit of money for the property. And there's some frustration on our side of dwelling on the use, if you will, and having a peer review of the use when it's been my position all along. And now I think substantiated by town council, that site plan review is not a regulation or review of the use. So it was an effort to say, can we narrow the issues and get towards a decision? And the planning board need not worry itself about the use, not only because the zoning bylaw says it's an allowed use and that the site plan review criteria are what they are in that section, but add to that it's regulated by a division of the Commonwealth. So there's the aspect of preemption, which I'm familiar with as a town council, right? So with that, it was an effort to, can we focus on the site plan review criteria? And is there anything else that you need relative to that review criteria to get us to a decision on the property?
Okay, so are you saying that you don't want to do a radiation peer review?
Correct. That's a regulation of the use, yes. It's not relevant to site plan.
Okay,
We're not a specially permitted use.
okay. Are you still, is there still an appeal on that variance?
Yes, in the land court.
So even if we said yes right now, you still couldn't break ground?
That's true, right? Yeah, that's true.
Okay. All right. I don't know if I have some comments. I don't know if the board wants to have any questions or comments in general. No? Amy?
I mean, my specific comments are just general. We agreed to a peer review way back when we met with all the STARS people. They were happy to do it. We spent time coming up with questions, and I just want to get the peer review out so we can get going. Like, I feel that all the questions were necessary, and I just want to get it moving just as much as you do. But COVID came in, and then all of a sudden we're at a standstill, and I'm hoping to ask Kathy later where we stand with the review process. But I feel to make a well thought out decision that's best for the town and best for the applicant, I just want the peer review to go out and go forward. But that's my statement.
So I think that, we keep coming back to use. And my comment would be when we first opened the hearing, we opened by saying that, just to be aware that we have questions about the use. And as part of peer review, we wanted to see data and facts that support the operations, meet the use criteria outlined in our bylaw. And we acknowledge that we couldn't regulate the use. But, from what we're hearing from council, as we've said way back then, as his original opinion had stated, the zoning interpretation sheet is informational only. And it was clear to me, and it's still clear, that the board has concerns about whether or not this is a light manufacturing use. And we
Okay.
were hoping to figure out through peer review, is this, light manufacturing? I will say there have been a couple of things that have been said. So I went back to listen to all the hearing because.
May I respond to that first?
Oh, please, sure.
And respectfully, that's the role of the building inspector. And, it's not the planning board's role to decide if the use is allowed once the building inspector has made the determination. If someone wants to appeal that determination, they may, and that goes to the ZBA.
But it's just an information sheet. That's what we keep
But-
asking.
Well, if anyone wanted an official interpretation, they don't go to the planning board, they go to the building inspector.
Well, do we have an official interpretation? I've never seen a written appealable decision made.
Well, the planning board has asked the building inspector at least twice, to my recollection, if the use is allowed, and he responded yes in public meetings. And then you asked town council, and he concurred with the building
But
inspector.
where is the written appealable decision for which to appeal? Somebody can't appeal a verbal comment.
I think but that's not part of site plan review, right? I mean, if you have that issue, you can address it or attack it in some other forum. It's not part of it. Like, it's like saying, if I needed a variance, you're going to decide whether the variance was suitable. Well, that's the ZBA. The interpretation on the use is the building inspector. If someone wants to appeal that decision.
But where is the decision, I guess? Where is that sheet that?
Well, this is how I can't invent a new way how this has always operated, which is you go to the building, you look at the zoning bylaw, you ask your client about the proposed use, you visit with the building inspector, he makes a determination, and you proceed. There's, that's how it's done. If someone wants to appeal that, there's a process for that, and it's not in site plan review.
So I don't see, maybe you don't need to have the answer to this, but my struggle is there is no sheet. That was an informational sheet. There is no written appealable binding decision. And I guess the board wait a second.
Uses are allowed.
But if the board has questions about whether or not it's the correct use.
Right. As I say, there's a different forum for that. It's not site plan review.
Okay, so far, then we shouldn't be looking at a site plan approval if we haven't agreed that it's.
No, the building inspector has already made that determination. So here we are.
Bob, would you call your zoning information sheet your determination that's a bindable, appealable decision? Or is that just a sheet that you create for the applicant's benefit? You called it customer service earlier.
The interpretation sheet is designed for customer service and to give a guidance, okay? In my 7 years as a building inspector, I've never run into the situation that I'm seeing tonight. If, however, it will make everybody fine, I will draft an official letter on my department letterhead stating that the use that they're proposing isn't allowed use according to the town bylaws. And then if the planning board has an issue with it, I would have to agree with the attorney that the Board of Appeals is the only person that can overturn my ruling. But I can have that document out probably tomorrow afternoon.
So then we'd have a written appealable decision that we could look at, that would look at use. And then how would one prove, when you go to the ZBA, what is that case where you have to prove it? Do you just get to, you would have to support, you still have to support with data and facts that you meet the criteria for that use?
They've met all the criteria for the use for that particular zoning district,
Yep.
in my opinion. You know, the zoning board of appeals is there to overturn or agree or disagree with whatever determination, not interpretation, I make.
Okay.
Okay, and you know, it's not the planning board's job, you know, to try to deny the use of a property. It's purely the ZBA.
Got it. So at this point then, what we're looking at right now, we don't have that. Right now, we have an information sheet that is currently not a written appealable decision. So,
Well, what you've had is you've had 2 live discussions, which are obviously archived, and a letter from the town council affirming my interpretation. What you're asking for is a piece of paper so that you can put it in your file. So I'm happy to supply that to you by the end of the day tomorrow.
no, I'm not looking for that. What I want to make sure.
Yes, you are.
Yeah,
Well, technically, I suppose I am, good point. Technically, I am looking for a piece of paper. But I guess when I go back to the original interpretation by council, what was said to us is the following. The zoning interpretation request form states on its face that the interpretation is for informational purposes only and does not give permission to construct, alter, demolish, etc. By its terms, it's a document used for purposes of information to a prospective zoning relief applicant and for the purposes of administrative assistance to the town's land use officials and boards. If we wanted to look further, the restrictions for the industrial use light manufacturing is that it is free from neighborhood disturbing agents, etc. That's what we focused all of these hearings on, because we're wondering, is it really free from neighborhood disturbing agents? And this is what's been said in response to that. We've heard, and I went back and looked at the hearings, specifically, the 12-foot walls is what is making everyone safe. And when we said, well, how do we validate that? How do we know the walls don't disintegrate? The STERIS team replied, that would be a good question for peer review. And then we were told 12 feet thick walls are like the lead vest. That is what is needed to contain the rays. That's what makes it safe. So you have a use that requires 12-foot thick walls to make it safe for all the people that are in the neighborhood. And you don't want to answer questions about the walls.
we
Even though
have answered all kinds of questions about the use.
excuse me, I'm just reading what was, I went back and listened to every single hearing, and the answer given to me was that it would be a good question for peer review. We asked the impact of radio frequency, and we said, and the answer was you'd have to refer to the radiation expert for that. At one hearing, we were told by you specifically that the process is emitting electromagnetic radiation, but it wasn't, but you took emitting to mean outdoors. And then in the report, we got information that there is some outside of the shields. So it is that outside? Is that inside?
Could you cite also all the times I objected to the review of the use under site plan? Every single meeting. But I said we were willing to dispel the fears of people about the technology. We were willing, STERIS was willing to provide all that information.
And now you're not.
No, no, my letter said that it, and I think town council affirmed it. I don't know why that doesn't resonate, that under site plan review, you can't review the use inside the building. And so, you know, to pay for peer review for that when you can't impose any conditions, and the fact that it's preempted by state law seems like an exercise in futility and a waste of time to me.
Okay, does the board have any questions? Amy?
It's just what I stated before. I mean, at the beginning when this started, everybody at that meeting that night were in the library, and they came up and shook our hands after the meeting, and they assured us that peer review is fine. We'll answer whatever questions you have. So I And we took the time to do all the questions and put together the peer review. I just think we need to go forward with it. I don't know why we're going backwards.
Can I ask, have we not answered all the questions that were presented to us? I mean, I've spent hours and hours on, you remember before you put the RFQ out, you hit me with 25 more questions that I responded to. Before that,
Right.
there was 16 questions,
This
almost
is
all about the use.
this is a huge use where there's
I-
not one of these other plants in the
So-
United States at this time.
No.
Under purview of the planning board, we are to protect our town. So, and peer reviews are allowed in our bylaws. And if there's any case for a peer review, this is definitely one of them. And I feel strongly about it.
Well,
Other board members have questions?
No, I think that I'm also concerned about what the use is, seeing it that it really doesn't have a precedence in this country at this time.
there are two other sites that have been permitted since we started here in Northborough.
One in California, where's the other
Yeah.
one?
I think it's in Illinois. But,
Um,
that's, so just for the perspective of the applicant, our view is it's an allowed use in the industrial zoning district. And all that was required was site plan review. And there were a lot of concerns about our use, so we were willing to share that information and answer questions. We didn't expect it would be opening the door to your use isn't allowed, or we never believed your use was allowed after a year. We were doing a good faith effort to assure you that there was no risk associated with this use. Steris has employees that are concerned about their own safety.
Mhm.
This isn't some run-of-the-mill, random operator. They've been operating in town for over 30 years, I believe, as a good citizen. Talk to the
well,
fire department.
Well, actually, there are quite a few non-compliance.
I don't think
references
so. Bring the fire department in.
No, I'm not talking about the fire department, with DEP, with the state.
Well, I don't know if anyone on Steris wants to respond to that.
Well, it's on the other property, of course, so this isn't, I don't want to speak of the other property at this hearing particularly. I guess my concern is you've answered the questions, and thank you for that. It's been, there are a lot of questions, and we've acknowledged that over time. I cannot make heads or tails of it because I'm not a radiation expert. So
Right.
the reason for a peer review is for someone who has that expertise. You could be telling me anything, you could be making it up or using a different language. I can't interpret that. I need
But
somebody to
do you-
look at it.
Do you not accept that the building inspector made a decision about the use and you can appeal that to the
Well, my
Board of
problem
Appeals?
is when this first started with the ZBA at the hearing, they originally asked about use. And you very strongly told them that they had no right to ask about the use and that their only thing they could look at was the variance. And
We were there for a dimensional variance, yes.
And a couple of the members though had questions about use and they really weren't sure about it, but they were told that they couldn't talk about it at all. And then it came to the planning board, and this is exactly what I said at the very first hearing. And then we were told we couldn't talk about it at all. We just had to
No,
assume it was true, that this is what happened at the first hearing. The problem is it started off with, no, it's not an electron beam. Oh, wait, it is an electron beam. Now it's 2 electron beams. And you want to put a radiation facility next to a neighborhood and you
it's,
can't act like it's an ice cream shop. We want to know what is the.
it's an industrial zoning district with an existing building, and the use is allowed, and it's regulated by the Commonwealth DPH. We answered questions about the technology. When we applied for a dimensional variance, the use isn't a concern. But by the way, at that first hearing, if you recall, when we were setting up to do our presentation, you told me, I think you're entitled to a fair hearing, but I'm going to tell you that everything you present is going to be subject to peer review. I've never heard that before I presented, even stated my name, that's the kind of reception we had. But I thought if we provided as much information as the board wanted to allay fears of the neighbors about the technology, which is electrical generated and goes on and off, as you asked all those questions about it, it's pretty safe, so I mean, but it's not subject of site plan review. So if you want to appeal the building inspector's determination, the path is a Section 8 appeal under Chapter 48, Administrative Appeal, to the Board of Appeals.
I'll tell you exactly what I said at the first hearing because I went back and watched it.
I did
And
too.
Yep. I said, be aware that I have questions and concerns about the use. As part of peer review, I'd look to see data and facts that support that the operations meet the use criteria as outlined in our bylaws. I clarified I was not looking to verify whether the use was permitted, but rather that it meets the performance use standards. I said I'd be seeking peer review to confirm that you meet the performance use, that it meets the performance standards of the use as outlined in the bylaws, and in fact are true light manufacturing. And I expected data and facts to support that, and noted that the application lacked facts and information. The original application that came in had very minimal information at all, from what I recall.
Because I understood it as a site plan, right? And so,
Well, you still need to do a proper narrative and presentation. You can't just say, this is an approved use, please approve it.
I think you can when the building inspector tells you it's allowed use and you're subject to site plan review.
All right,
That's
well,
kind of
we're
what you
gonna
do.
go round and round on this.
Well, I don't know why the town council's letter doesn't resonate. I'm just kind of disappointed. I don't know if board members didn't have a chance to read that letter or
Well, I
what,
think
but
what he was saying was that, and board members, please jump in, that we need to not, we can't look at the indoor use. And I think what the board members asked was, what if it's not indoors? What if it's radioactive emissions that end up outdoors and gases and the carbon dioxide? What happens when that's outdoors? Then what? Is that, if it's emitting radioactive emissions, which that might be a double statement, outside, how do we know that it's staying inside? And these are what our questions are based on. You want to put 2 electron beams next to a neighborhood. We gotta know that that's
Well,
going to be safe. That's not going to get outside.
you know, I object to that characterization because it's an industrial zoning district. The voters of the town of Northborough adopted the zoning map to say industrial use is an appropriate use on this land. And, you know, Steris bought it knowing of the zoning designation. It's not like we're forcing it in because that's how this property is zoned. The voters of Northborough by a 2/3 vote decided that.
Wait, I'm sorry, but which medical, which use is this defined as? Medical product warehouse, X-ray sterilization, distribution office? That's what I have on the zoning form. So the voters wanted X-ray sterilization. That's not even in our use table.
Well, I mean, if they zoned it industrial, it's an umbrella of uses that would be allowed under that designation. And this is probably the least offensive of the types of uses that could go into an industrial zoning district. I honestly believe that. It's clean.
Okay, so what do you want, if you don't want to do a peer review?
I'm going to ask my client if I may.
Oh, Amy, go ahead.
I was also going to note in 2008, before the 2009 zoning law changes, in the industrial, there was biomedical, biotechnology, bioprocessing, and pharmaceutical uses. Now that was taken out. And I know we're not here to talk about use, but you just read all those uses. It sounded like it would fit under that, which was actually voted out by the town of Northborough by 2/3 vote. And now it's light industrial. And when I looked up the definitions of light industrial, it was taking a raw product, like say a piece of, I forget what it was, but it was like a raw product. The manufacturing was to change this product into something new. And that was the definition of manufacturing. It was you had a raw product, and even like they considered baking not manufacturing because I forgot why, but I didn't think we were going to be talking about this tonight, so I didn't look into it. But manufacturing was taking a raw product and you had to change it into something that was different than what it started.
Right, processing is also allowed as light manufacturing processing. So if you look up the definition of processing, I think this use would qualify as that for light manufacturing. And I put that in one of my 3 memos to the board as to defending the building inspector's determination and the town council's determination that it's an allowed use in the industrial zoning district. Processing.
Okay, but it still has to be free from electromagnetic,
I
free from
think
neighborhood disturbing
If you
agents.
read, it says in accordance with state regulations, and we will comply with state regulations.
No, no, not that section. It's just the definition of light manufacturing is the use be free from neighborhood disturbing agents such as odors, gas fumes, blah, blah, electromagnetic radiation.
Yeah, I think we comply with that. I don't think anything goes beyond the property boundary.
But that's what we're asking. You said, don't worry. The
We
only
s-
thing keeping you safe is that it has 12-foot thick walls. But we're not
No,
gonna, we're not gonna
look
have
at-
anybody, we're, the only thing keeping everybody safe, and I'm gonna read it again because this is what was said to us about this. The 12-foot walls is what is making everyone safe. The 12-foot walls are the lead vests. That is what is needed to contain the rays. That is what makes it safe. So we're saying, well, we know nothing about these concrete walls. We don't know if they last. We don't know what if there's an earthquake. We don't know what if there's a crack. How long do they last? What if, I mean, we're asking all these questions because what you've said to us is if something happens to those walls, those rays aren't contained at all. And now they're going outside, and now the neighborhood is not free from neighborhood.
No, we gave you responses how the system shuts off. I mean, look at my
But I'm not
most
an
recent,
expert. I'm not an expert to understand. Well, you tell me that, but that's not my field. So how am I to make?
well, I know you don't accept anything that we present. I understand that, but look at my most recent memo, the one that was, I'm trying to find it, that, before you issued the RFQ, when you said you had a few more questions, and there were, I can't remember the number, like 18 about the use. And we provided all those responses about the use. Steris had its teams from around the world providing the responses. I mean, maybe that was the mistake on my part to say that, you had jurisdiction over use, but I thought if we gave all the information you wanted, it would satisfy the board. And I never thought that you'd say after a year that the use is not allowed and
No, I think we've been trying to figure out by way of showing this data, does it actually, like we said, we're looking to find data and facts that support it. We're asking the questions we've asked, if correct, if you submit the data and facts, it could very well support it. But
I provided that, I don't have the date of that memo. I think it was in May. Because you would, you held the RFQ because you wanted those additional answers. But I work with a lot of people from Steris from around the world on those answers. There were questions like, how many racks are you going to have? I didn't even understand somehow you guys knew more questions about the technology than I did, or more. And so we've answered all of that.
Okay, does everybody on the board feel like you can look at the RFQ responses that have been provided to us and understand what's been presented, whatever questions Steris has answered, and understand it and be able to make a decision based on the answers we have from Steris? When you go through the book, can you understand? We've been given all the answers in our book. Can you read through it and understand it and feel confident that you're able to make a good decision?
I do not.
Michelle? Michelle, can you hear us?
Yeah, I don't. We agreed to a peer review.
Anthony, do you?
Well, so yeah, I mean, there's just so many things here. There's, first of all, Steris has agreed all along to do the peer review and never limited the peer review with doing anything to do with the radiation. I know we've got a neighborhood over there that's extremely concerned. There's a technology that has not been turned on in the United States yet. And we're just taking at face value that everything's going to be okay. And I think even from Steris's perspective, you would want to at least have, be a good neighbor and make the folks feel safe that are so close to this plant that needs 12-foot walls and ceilings to contain the technology. And furthermore, I mean, I don't even understand how you could ever come to the conclusion that anything that requires a 12-foot wall is light industrial. So I would strongly suggest that we move forward with the peer review, including the radiation component of it.
Amy, any comments from you? You feel confident looking at these answers and?
No, we were promised a peer review, and I'm expecting to go forward with the peer review.
Okay, so where we're at this point is, it sounds like the board would still like to see a peer review. Obviously, you can elect not to move forward with that. Um, if you want to, I mean, I guess we can, move to close your hearing and on to make a decision if that's your preference. I think.
I just want to clarify, everyone was stating that we agreed to a peer review. I certainly think if I was agreeing to that, I always understood site plan review to be the review criteria as set forth in the letter from town council. And not the use. Again, I think I said at every meeting that I appeared at that this is not a review of the use, the regulation of the use, but apparently that never carried in with any member.
It's not that. I feel like you've picked out. I'm looking at what was written from town. I see what town council said about indoors. I acknowledge that that was written to us, but we have other opinions from town council that told us there are standards that govern this, and there are the following performance requirements. So we're asking our questions based on these different requirements, and we're asking these questions to assure us that radiation is not going to escape the building. I recognize that it's regulated by the state. We're not suggesting that we're regulating the radiation. We're not telling you how many electron beams you can have in there. We're trying to figure out, is this going to be a situation that creates radiation outside of those four walls? Because this is the first of its kind in the US. It's the magnitude of X-ray sterilization that it's complex for us. We're not trying to.
Right, I'm just trying to go by the bylaw, but you know what, if you can, how long before you could get a peer review? Because again, we're a year out for site plan approval.
Right. I mean, I of course I understand that, and we want to be timely, but at the same hand, you're again, it's not like we're holding you up from breaking ground. You still have a variance appeal.
Well, we're moving to dispose of that onto, and this isn't, obviously, this is an expense for Steris every single time.
Okay, but what do you mean you're moving to dispense from that? You still have, you still are going through the system right now.
No, but I never would have told Steris that this site plan review, anyway, it doesn't matter. So I'm told there are three
Do
other.
you want to look through the questions and decide which do you feel are related to indoor use? And maybe if there's something you object to, then we can consider that as something.
No, what questions?
Well, no, the questions that we've asked, I'm stating that we've created our questions around supporting data and facts and making sure we meet the performance requirements and all of that. If you feel that our questions aren't around that, and if our questions are saying, anything that implies that we're regulating the use rather than just questions about the project, then do you want the opportunity to remove them from the RFQ, or would that make you feel like this? Would that change things for you?
No, I don't need to review them. But I do this RFQ process, Chapter 30B has a $50,000 threshold for obtaining quotes. And that would be a more expeditious manner to get a peer reviewer than the RFQ process.
Oh, I don't know. That was through the town. Kathy, do you have any comments on that? RFQ versus RFP?
No.
I had originally written this as an RFP, which is a request for proposals, and without an assistant town as an assistant town administrator right now, who serves as our procurement officer, the DPW director is very involved and has served elsewhere as the procurement officer. So he reviewed the RFP, and it was his determination that it should be an RFQ. The RFQ is, I can issue it tomorrow. I'm just waiting for the planning board to say yes on reissuing it. And, it's just a matter of me, editing the dates, which, I can do tomorrow afternoon.
And I don't feel it was us as a planning board holding it up. We were supposed to talk about it on September 1st, and then our meeting was canceled. And we even threw out a date the next week, and we're told that we couldn't meet until this week. So everything we do has to be done publicly. I don't feel that any of this falls back on us.
Again, I was just objecting to the effort to review and regulate the use under site plan. And that's what I think has substantially delayed us.
Yeah, the other thing, so just to state, I don't necessarily agree with some of the comments that you've made. I don't necessarily agree that town council has absolutely said this is the right use. I think there's been different opinions given in different instances, and what we've followed along with in the beginning was the opinion, a written opinion from town council that was provided to us when we kicked off these hearings. This wasn't something, the board did not make up performance requirements or how we would ask questions or the need for data and facts. We have a written.
I didn't say that.
Okay, so, and we did not, look at the zoning information sheet as a determination by the zoning inspector. We were told by our council that it was simply an informational sheet only. So we didn't look at Bob's sheet and say, well, we're not gonna, this doesn't apply to us. We looked at it as an information type form, not.
But you undermine the whole system if you don't accept the building inspector's determinations.
Well, there's a way to appeal that in any case.
Right.
Not
That's right.
undermining it if you don't agree with it. You simply don't agree. It doesn't mean I think everything that every determination is incorrect. I just, in this case, as the process became more clear, I don't
No,
know.
I agree. I've said that, right? If you want to appeal the building inspector's determination, you go, there's a path for that. It's with the ZBA,
Right.
but it's not through the site plan review process of, you could, it's separate.
No, we're actually going in this review, we're going along with the assumption that it's light manufacturing, but we'd like to know that it actually, the standards that govern noise, light, and also specify the following performance requirements are met. And our questions are based around these types of questions about meeting these standards and meeting the standards of the use. You can't just say you're light manufacturing, but you have, electromagnetic radiation coming out the windows into the neighborhood and say, well, that we can do that because we're light manufacturing. There are standards that apply. And that's what we're trying to find out. Does this use meet the standards? I think the problem for us, and maybe why we keep seeing this through a different lens, as I've said before, and maybe you heard me say it, if it's a product that you're processing and I can see it with my eyes and I know when it's outdoors or indoors, there's not that gray line of, I'm not going to try to tell you, you can only make, orange widgets today, that the planning board's only going to let you make orange widgets. It's the electromagnetic radiation and the gases and all that, I can't see. So it's not as clear now what's indoors or outdoors. And that's what sounds to be a concern with the board has been expressed over time is, can we just be assured that we'll keep it indoors, which you can do whatever you want. You want orange, purple, green widgets, that's up to you. We just want to make sure that all your widgets aren't going out the window and into the neighborhoods.
Well,
Are you meeting performance standards that prevent that from happening? And normally at this level of scrutiny is because radiation is scary to people and it's scary to the neighbors. And our job is to ensure the safety of these projects.
No, I don't think, I think it's to review the site plan in accordance with the site plan criteria. And
Well,
it's DPH's job, it's the job of the Mass Department of Public Health to ensure the safety of the technology.
Well, I don't know if we
That's
agree.
the difference. How can that not be? I just gave you the statute and the regs.
All right. So I guess we're at a point where we have two paths we can take. Does anyone have any additional comments on this? Board or staff or anyone? Okay. So I guess we can take two paths at this point. Either we continue with the peer review process and move forward that way, or if you've elected to no longer do that and you want to, stop here, I guess we'd have to figure out what any additional information before we close the hearing, if there's anything else we need, or else if we can just close it, we can certainly do that as well. So do you have, I guess really it's in your court what you want to do for peer review or not.
Okay, if I could have a minute.
Sure. Do you want to get removed from, do you want to go back into the audience and?
Yeah, I don't know what else is on your agenda.
Well, we're still in the here. We haven't, well,
I mean, Carrie, you could just suspend the hearing, temporarily until, the applicant convenes and then, comes back to the meeting. I mean, that's been done before,
okay.
and then if you
suspend-
wanted to jump to the minutes or something.
Okay.
Yeah.
Do we need a vote to suspend or amount of time to suspend?
No, I think you can just simply state that you're just, temporarily, stopping the conversation, the discussion at the public hearing while the client or the applicant, discusses with their client.
Okay, so we will, sorry, Stephen, is that what you want to do?
Yes, please.
Okay.
I would appreciate that.
And then just reconvene when he comes back on.
Okay, so we are going to suspend the public hearing for 425 Whitney Street, special permit site plan approval and special permit for groundwater protection overlay. So to give the opportunity for the attorney for the applicant to reconvene. And Stephen, why don't, when you are ready, you just raise your hand and I
Okay.
will send you back.
All right, thank you.
All right, let's see. Okay, so why don't we move on to old business? First on old business is consideration of the minutes. So first we have the minutes from August 4th. Did everyone have a chance to read the minutes from August 4th?
Yes.
Okay, any comments on or edits to the minutes? Does anyone want, I'm sorry, did you raise your hand, Millie?
Nope, I don't have any questions.
Okay, does anyone want to make a motion to accept the minutes as submitted?
I make a motion to accept the minutes from August 4th as submitted.
Okay, a second.
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 All in favor? Roll call, Millie,
Aye.
Michelle,
Aye.
Anthony,
Aye.
Amy,
Aye.
Carrie's an aye. So the minutes pass as submitted. Did everyone have a chance to read August 18th minutes?
Most of them.
What? I did not get a chance to read the August 18th minutes. Did everyone else but me?
I read them, but I'm fine waiting, so you can read them. Because I think you made a lot of statements, so it's probably better to let you read them.
Can we continue these? Okay, so we'll continue the minutes for August 18th until next time. Why don't we go on to ZBA applications for September 22nd?
I didn't really have any to talk about there, but I did on the 29th.
Okay, so I guess just in general, the next few, the 2 very busy weeks coming up for the ZBA.
Yep, if you just want me to go through those real quickly, Carrie,
Sure.
the, again, not all of these, not all ZBA applications involve a site plan approval or not. So coming up for the, on the 29th, if you want to skip over the 22nd, I mean, you've discussed the applications that are on the 22nd, but on the 29th, 50 Southwest Cutoff, is coming before the design review committee actually tomorrow. And that is, that particular project is all before the zoning board of appeals, and the site plan is before the zoning board of appeals. 17, and what that is that's two contractors' yards that are being proposed. 17 Mayflower, 17 Mayflower is a garage or carport. I think it's a carport that's being proposed for a single family house. 399 Hudson Street, that is before you on October 6th. That is a duplex. That's something that I need to come up with a modification in the zoning bylaw, because right now, this is only the second time it's happened, but it's just not an efficient, and we didn't mean for it to happen this way when we first wrote the zoning, but anyone that's coming in for a duplex has to go to the planning board and the zoning board of appeals. For this particular one is a special permit because of groundwater. Is that correct, Fred? I think it's groundwater. And then therefore that requires a site plan, and then it requires a special permit for the use before the planning board. And then that also kicks off a site plan. So to have two boards doing a site plan just doesn't make sense. There should only be one, permit, site plan approval authority. So we can talk about that when we start to talk about potential zoning bylaws, but so that's what's before the ZBA on September 29th, and then the same project is before you on October 6th. And then 11 King Street is an addition to a single family house. So those are the four applications, the four new applications for the ZBA.
Kathy, I'm just curious, what kicks off Southwest Cutoff going before the ZBA? Just explain that in case anybody has a question.
The Bob might be able to.
Is Fred talk? Fred, if you're talking, we can't.
Yeah, I believe it's in a business district, so that is site plan with the zoning board of appeals. The planning board covers. Wait a minute. Oh, they need a special permit. Bob, do you remember? I don't have my ZBA files in front of me. I'm sorry, but
I
for
don't have it in
50s,
front of me either, but it was something about.
I can go grab it, Carrie, if you want the details, but
Yeah, the
Came in the mail?
use is going from a contractor's yard to a contractor's yard was allowed by grandfathering. I think the ZBA had to chime in because I think it's in the groundwater, but I'm not sure. But it is two buildings on the same lot.
yeah, two buildings on the same lot, and then groundwater in a business district.
Yeah.
And that's what puts it before the zoning board of appeals. And then therefore, since the special permit is with the zoning board of appeals, that's where the site plan approval is.
Mhm.
So like I said, again, that 50 Southwest Cutoff is before the design review committee tomorrow, along with 399 Hudson Street, and then along with a ZBA application that's been kicking around for a couple months, 56 Hudson Street.
Right. Thank you.
I have a couple of questions on two of them. I'll do the easier one first. 399 is the duplex. And it did come in front of groundwater, and we had some comments. Would those go under the site plan or under the groundwater decision, Fred? There was some comments that the duplex can only be 6 bedrooms. So it had to be on the deed, and it also was going to be on the occupancy permit that only 6 bedrooms was allowed. So I was going to ask, is that added to the special permit decision or the groundwater decision? Because as you said, it's coming in front of 2 different boards.
Well, the special permit is for the groundwater. So that's what the ZBA is seeing it for. So that will be in the ZBA decision.
Okay,
That because the ZBA is the special permit granting authority for the special permit for the groundwater, 399. And then the planning board is for the
use.
use.
Yep. So I
And
want,
I mean, the planning board could make that a condition also. It wouldn't be reflected as a groundwater condition, Amy, because you don't have the jurisdiction, but you could put that in as a condition that, that it not to exceed, 6 bedrooms,
yeah.
to mirror what the ZBA would be saying.
When we talked about it at groundwater, they said it would be on 2 different things. It would be on the deed and it would also be part of the occupancy permit. And another thing we talked about was with the applicant, because it does have 4 rooms upstairs and with a closet and a window, it means it could be a bedroom in the future. So the applicant agreed to take the closet out, and that might be something that design review might talk about too tomorrow, because he did agree. Remember, Fred? He
Yes.
didn't want to take out a window because Bryant said before when it went in front of the Board of Health, if it had a window and a closet, it would be a bedroom. And so in the past, they probably wouldn't have allowed it. But the applicant agreed to take out the closet. So, because not saying that he was going to have 4 bedrooms, he has it on as an exercise room and an office, but he agreed to take out the closet. So those were other than the groundwater conditions, and I'm sure Fred will write a memo on, we were talking about occupancy permits and deeds and closets.
You got to be careful about the building code and a bedroom definition in the closet. Closets are not required to be in a bedroom under the building code. So if he's building a 3-bedroom a 3-bedroom duplex unit with a 4th room that is available as a office, workout room, wrapping room, whatever, okay?
Mhm.
The occupancy certificate will state that, okay? Plus, it will be a deed restriction to restrict it to a 3-bedroom. And that's about as far as we can control legally the interior use of that building.
Okay, well, that was the discussion that we had at groundwater. I just wanted to know, since it's going to the planning board and the groundwater, which decision it was going to be attached to.
So if I could just weigh in on that, I haven't seen it yet, and it is coming before the board tomorrow night. But I've seen in many, many of these projects that even though, as Bob is correct, a closet does not define a bedroom, they still go online and will say it's a 4-bedroom, even though it is also deeded as such. So what a lot of people require them to do is keep it as a loft area up there. So I don't know if the applicant would be open to that, but instead of 4 rooms on the 2nd floor, maybe he has a loft, 3 bedrooms on the 2nd floor and a bathroom up there.
I would caution everybody to be careful and review their Chapter 40 zoning requirements in terms of the limitation of regulatory or special permit granting agencies, whether it's ZBA or planning, to regulate the interior layout or use of a single-family residence.
Okay, it was
So
more
I'm
of a
just saying,
concern
be
for
careful.
groundwater, because groundwater said there can't be more than 6 bedrooms, no matter what, because of it is a septic on groundwater, and they were that's as many bedrooms as you can have.
So it's
So,
on septic versus sewer?
yes,
Okay, well then they can only advertise as 3 bedrooms because it's a 3-bedroom septic system.
yeah, and they
Right,
were,
Bob? They're gonna build a 3-bedroom septic system for each unit?
Yes.
Okay, that's fine. Be different. if
The
it's
reason it's limited to 6 bedrooms total for the building is the size of the lot.
Okay,
It's 220 gallons per 10,000 square feet. They have 30,000 square feet, so they're allowed 660 gallons. as we discussed at the groundwater meeting, it could be 4 bedrooms on one side and 2 on the other, but a
Yeah.
total of 6 for the lot. They have
Okay.
2 septic systems, one for each side. I haven't seen the septic system designs, but I would assume that they're both laid out for 330 gallons for each side, so that there would
Okay.
be a maximum of 3 bedrooms per side based on the size of the lot.
Okay, all right, that works. Okay. That makes
Okay, and
sense.
so Kathy, you said it would be noted in both decisions, the groundwater and the planning board?
Yes.
You can, if you want to write your decision that way. I mean, the appropriate place for it to be is in the ZBA's decision because they're the permit granting authority. But the
Right.
planning board could also, if you so vote, you could put a limit on the number of bedrooms to reflect the groundwater information.
Okay, so since the ZBA doesn't have a person on the groundwater committee, you'll add it to your memo, Fred, going to the ZBA because,
It will be in the memo to the ZBA because it's part of the zoning bylaw that signifies why they had to come to groundwater to begin with. It's one of the criteria for
okay,
the lot. So it is a groundwater condition.
okay. So I just wanted to bring that out.
What
And
is,
then,
oh, go ahead, Em.
oh, sorry. If you have a question on that one, I have a question on a different one.
Well, I was just going to comment, but to your point earlier, Kathy, what a potential predictable mess, because what if we have conflicting conditions? What if one board has one set, and the other board has another set, and one of the conditions don't agree? That would be an interesting conundrum.
Right. I mean, that's why it should only be one board. There should only be one special permit granting authority per project.
All right, sorry, Amy, go ahead.
Okay, that's okay. My next discussion was on 50 Southwest Cutoff. And I was hoping the planning board could discuss this one and maybe even write a memo on this one because I found a lot of different things when I reviewed it. And it does say the planning board can write a memo or shall review it. So 50 Southwest Cutoff is 3 sites. 2 are on Business West and 1 is residential. But what they're doing right now is the second building is actually encroaching on residential. So I see that as more than a grandfathered use. I mean, when you do non-conforming, the non-conforming is supposed to be similar or less detrimental per our recent bylaw changes in 2019. When you talk grandfathering, that means the buildings stay exactly the same. They're not torn down. The person comes in, they're doing the same thing. The old buildings are being torn down, replaced, and expanded. And the third lot that they're expanding on is residential. So instead of having an industrial buffer of 100 feet between industrial and residential, it's actually growing onto residential. And there is no buffer now between residential and industrial. And it's an industrial use, even though it's in Business West, it was a contracting yard, which is a business use. I mean, an industrial use. But in the past, when you have an industrial use in business, we've used the industrial zoning criteria because it is supposed to protect the buffer between residential and industrial. So there were a couple things I had questions on.
Carrie, can I just put out a caution to the board that since this is the subject of a public hearing, an upcoming public hearing, and you don't have the applicant here to discuss their project, you should either invite them into a meeting if that's what you want to do, is discuss the project with them, or discuss it at the attend the ZBA hearing and discuss it there. But you shouldn't really be getting into the details of any project that's the subject of an upcoming public hearing.
Okay.
I would
so
love
is
to
this-
request it in front of us. I was going to do that on September 1st.
Oh, okay. Is this one where planning board has a technical review?
Yes.
No, this is I mean, the planning board can offer comments on any ZBA application that they want to, but it's not anything that's required by law. And it's the ZBA that's the permit granting authority and the site plan approval authority on this particular project because of how it's zoned.
Oh, okay. And Amy, there's somewhere in this that we're providing comments. You mentioned
Yeah,
that.
I'll have to find it in the book, but when,
Yeah, the planning board can always offer comments, and in the past, the applications that you've wanted to provide comments on, you've had the applicant come before you so that it's in, it's a public open process.
Okay.
yeah, because it said the planning board shall provide comments unless, and if they don't, then it's noted that we agree with everything. So actually, this one, I did have quite a few items I wanted to talk about. So I would love if they would agree to come in and meet with us before they went to the ZBA. But I don't know how we would get that agreement and know they were coming before us.
No, you would have to, you do two things. The board would take a vote if that you want them to come in on your next, invite them into your next meeting. And then I would, forward that request to the applicant. And then you would also, because your meeting is after the ZBA, you would need to send a letter to the ZBA asking that they would, continue the hearing till after you have met with the applicant.
I would like to recommend we do that. I don't know how the other board members feel.
Any other comments?
Yeah, I mean, I know we can't really talk too much about it because we don't have the applicant, but I did look over this and I did question some of the ability of the applicant to go into the residential, and there is a bit of a loophole that allows that to happen if they happen to buy that that next piece of property, which would be, I believe, 54 Southwest Cutoff. And I think they did that.
Okay, so if we have questions about it then, would we want to invite them to come in then so we can clarify that? So I'm fine with it. I just want to make sure if Michelle or Anthony, do you?
I'd agree with it.
I agree with it.
All right, so if we could invite them.
All right, so you want to have them come in, you want to have the applicant come in on October 6th, and then you also want to request to the ZBA that they keep their hearing open till their October meeting.
Yes.
I wonder, since we have so many things on for the 6th, should we, if we do it on the second meeting, it will still be before the ZBA because they meet at the end of the month. I don't know, or is that a risk? Should we just
Well,
put
do you
it?
want to see which one works? Maybe the second one works better for them anyway. So would the board be open to either date depending on what works better for the applicant?
Sure, I am.
Okay, so is that possible, Kathy, just to invite they can pick? Can you hear us?
Yep. Ask them if, I just had a ringing, which I don't know if that's me or the equipment. Ask them if the 6th or the 20th works for them.
Yeah. Okay.
And then could you write the email to the ZBA asking to continue so we can, so they
Yes.
can be in front of us? Okay,
Yeah.
thank you.
Okay, great. All right, so it looks like Stephen has raised his hand. So, any other discussion on ZBA applications? Nope. Okay, so I am going to resume the hearing for 425 Whitney Street, a special permit site plan approval and special permit for groundwater protection overlay district. And I'm going to bring everybody back in. So I have Stephen. I have Mike and I have Rich. I think that's the same crew. Did I miss anybody? Just raise your hand. Oh, Stephen, did I let you back in? Oh, I did.
Yes.
Okay. All right, I'm gonna just lower your hand then. Okay. Comments back from the team.
Sure. Well, first, I want to thank the board for allowing us that opportunity to confer. And I was reminded that we did, of course, agree to peer review. And I think I'm sufficiently on the record about the use, I would expect. But we are agreeable to the peer review. We'd like, though, the board already issued the RFQ and you had 3 respondents. We'd like for you to pick one of those respondents. I think they were qualified to get started in the interest of time, if that's available. You know, I don't know why none of those 3 were advanced, or maybe one of them was. But is that something that could happen to get this moving for peer review?
So to clarify on what happened the last time, we only progressed one forward, and because there was only one radiation expert, and then that person had technical difficulties and wasn't able to join the call. So we weren't
Right.
able to even talk to him or connect with him or anything. So it wasn't that we couldn't find anybody, it was that we couldn't connect to the person we needed to connect to. So that was really there. Kathy, I think you said you have additional experts that you've reached out to in the interim to provide in advance?
Well, I haven't reached out to them yet because
Oh, yes.
we had the reissuance on hold. But I do have 3 additional names that was provided to me by one of the original consultants that I found that had a conflict of interest and could not bid on the project.
Okay. So, but we're not having a problem with, I guess, general consultants. It's the radiation consultant. So to Stephen's point, could we pursue, taking a look at the 3 that we had, maybe reopening that? Do we have to reissue the RFQ to look at that, or can we already look at them?
No, we have to, because there, the time has come and gone on, when questions were due, when contract review was done. Because I had asked that question of our DPW director after the last planning board meeting was, could we just go back and we have to reissue it because we've gone through that. We've kind of gone through that phase. There was dates and the dates have come and gone. While we were sitting here tonight, I just redid the dates because originally I had a reissuance, which again doesn't, that came and went because of that September 1st meeting. But we could reissue it on the 23rd of September. Submissions would be due on the 14th, and then an award would be made on November 4th.
So we can't just send it out tomorrow and that's considered issued. Is that?
The only reason why I'm saying the 23rd is because I know what my schedule is like between now and I had looked at the calendar for all of that. So it's just given what I'm tied up with meetings and and being out of the office in meetings, so that I know that I can just properly do it. If I can certainly release it earlier, but I just don't see that. I have some ZBA decisions that have to get out, along with some other work. But so I'm looking at, and again, if I can do it earlier, if the board is okay with, sending this back out again, I guess my worst case scenario is that I would send it out on the 23rd. But so using the 23rd, those would be the dates, is that, the 23rd is when it would go out on the street. Questions would be due back on the 7th. Submissions would be due on the 14th. Between the 14th and the November 4th, we would look at interviews, and we need to talk about how to do that. And then, the award would be on the 4th. Then we would just, work out the contract, and then do an anticipated contract award on the November 4th, and then work begin on November 11th.
And then is there a way to
it's a holiday.
expedite and specifically send to the people that have already submitted, or?
Yeah, oh yeah, I would do that on the 23rd. If not, again, if I can get this out sooner, I will. But I'm just looking at my schedule, knowing when I can concentrate on this. That's why I picked the 23rd, and that's when I would release it and also send it out to the contacts that I have from that gentleman. And then the consultants that have already,
Mhm.
that originally submitted.
Okay. Any comments from the board on that?
What happened to the gentleman that we couldn't connect with? What was the follow-up on that?
There hasn't been, I mean, they both they both asked questions about, what was the hiring process,
Mhm.
and, the interview hadn't, you couldn't finish the interview that evening, and then it hasn't been rescheduled. And
So
then
if
there,
we go,
and
if
then
we
there
go
was
back out
just,
to him.
So we
right, and
could,
then there was discussion at one of at your, I think, end of your August 18th meeting about reissuing it. And then I sent out the revised, draft to everybody.
Anything else, Millie? Did you have another question on that?
so you sent out the revised draft to issue the request again, so you had to resubmit that, or?
No, I sent it out to all of you. I sent out the revised 425 RFQ with
Mhm.
the new dates but those dates have come and gone. Those were based on a release of September 2nd.
Yeah.
And then I also sent out everybody the general RFQ just to take a look at in the event that you're going to do, the board hasn't made a decision on that. And I'm assuming you'll discuss that on the 6th, but about whether you're going to do, any kind of peer review for Zero Bartlett.
Okay.
Can I ask a follow-up question
Sure.
through the chair? If it's available, so under 30B, the procurement statute, services for up to $50,000, you can solicit by soliciting for quotes, 3 quotes. And if that's available for peer review, could we go that route instead of the formality of an RFQ? You could transfer, I don't want to load up Kathy's plate, but if you could change that RFQ to a request for quotes that you sent out to the 3 respondents and anyone else that's qualified, you could retain an engineer from that process.
No,
much
I
rather-
think what the DPW director saw as the issue with that, Steve, was that that is just based on price, and you shouldn't
Yeah.
be doing a peer review just based on price. It shouldn't be based on price. It should be based on qualifications.
Yeah.
Because the price doesn't give us who's qualified or not. And the qualifications, the request for qualifications, that's why he changed it from a proposal to qualifications.
Right. I just think you would know who's qualified, Kathy, to submit, requests for quotes from in terms of engineering firms, site engineers.
Yep, that's correct.
Does it make it complicated to break it up so that, where we maybe don't have that quicker track, like for the engineering piece, can we do the RF request for quotes or whatever Steven suggested, and then, or is that just more cumbersome to divide?
Well, but again, it's not a price-based
Oh, okay.
project. It's a qualification-based project.
Okay. So given that, what does that, I mean, I guess that's the timeline we have. So does that, we can try to expedite as best as we can, but that sounds like what we've got on the table.
Right.
for
I mean, if I can get it out this Friday, because again, I know what Wednesday, Thursday, and Monday looks like, and then Tuesday is ZBA. So that's how
Right.
I arrived at the 23rd. If you want the dirty details, but if I can, if I can expedite it and get it out by the 18th, I certainly will.
Okay. Any other comments? Any board members or staff? Amy?
Next on our agenda, we're going to talk about the RFQ because I just had one change to it, addition.
For which one?
For this one, I just had a question.
Well, Kathy, can we combine, is it possible we talk about that while we're here so we can just solve?
Yep.
All right. My only question was when it went down to evaluation criteria. and it talks about a selection team and a committee, but it doesn't say who's on the selection team and committee. And I think, last time Carrie said she wanted to be included, and I feel that would be good if she is included. So I just want to make sure she's on the selection team and the committee.
Yep, that's in as part of the conditions of the award. Relevant departments of the town, including the town planner, town engineer, DPW director, and chair of the planning board.
Okay, I didn't find that on that one. I saw it on the other one.
Yeah, no, it's in it's the same language that we had in the first RFQ. So it's on page 3 under conditions of award.
May I ask then, so can a selection be made without the necessity of a public meeting if the chair participates with those other employees to select?
I mean, I think what my suggestion to the planning board is, so that we don't, the DPW director brought up a very good point of when you do interviewing in a public setting.
Right.
It's not required. And the reason why it's not required is because the first person in is always at a disadvantage.
Yeah.
The only person that's not at a disadvantage is the last person that you interview, because they are able to see everything that has been, all the applicants before them, all the questions that the board asked before them. So to make it a fair process, that's why interviews are usually done, in-house during the day. It doesn't matter that it has to be during the day, but I mean, we're now set up where we have, plexiglass, and we can have up to, I think it's 4 people. So, obviously we'll have to bend the rules a little bit or go into a different room so that we could have, 5 to 6 people, the 4 of us, including Kerry, and then, at least 1 or 2 of the applicants. So I would suggest that we do that, in-house, Kerry, and then, you report to the planning board who was chosen, and that certainly expedites the process, and is really the typical process.
Okay, do any board members feel that they don't want to be excluded from it? Is there any problem with that process for anyone? And I won't take offense if you aren't happy with that, so please be honest.
I think it's a great idea to move things along.
I'm fine. Yeah.
Okay, so maybe that can help expedite as well. Then we don't have to wait for hearing times, and if anything happens where we have to continue, we don't have to worry about that. One other thing that I wanted to make sure, I mentioned before that we had written this pre-COVID, and I think travel was a little different. The travel looks very different now than it used to. So I think, one of the requirements is that site visits are able to happen. So I wouldn't want to get someone from California who has to travel and maybe endanger themselves or come here and bring something and all of
Yeah,
that. So,
and I think that can be part of the interview process,
okay.
Carrie, as to whether or not they foresee that as a, if we get somebody from a state that can't, that's banned right now or something.
But should we even mention that in advance so that we don't have people from other states who we're probably not going to go with if they have to come from across the country? I don't want to waste anybody's time filling out,
I can find out if that's something I can add, or does it become, and I know this just sounds like big government, but if it becomes a statement like that becomes discriminatory. So let me just check on that.
Okay. Yeah, I don't want, and obviously there's quarantine rules, and if somebody has to come here and quarantine for 14 days before they can go on the site, that's going to make the process longer. So, all right, that was my one concern. So I guess timeline wise, we've already talked about that. Any other comments on the RFQ itself? Otherwise, it's the same exact thing, Kathy, with the dates changed.
Correct.
Okay. All right. And then you'll find out if there's anything we should say in advance about travel. I mean, I wonder if in the world of COVID, if that's not considered discriminatory at this point. I have no idea. Maybe in this environment, that's not looked upon as, you're excluding states.
Yep.
Okay.
I would hope we could find someone local.
Well, that would be great, actually, just to make it easier. And then we don't have to worry about that. And then whatever associated travel costs wouldn't be a piece of it.
And They may just be able to review the documents without, and, Google view the site.
Mm. Yeah,
Yeah, I think, that, I mean, in my personal opinion, it's the engineering firm that probably may be more, that it may be more necessary for them to look at the site, whereas the sterilization part of it, because nothing is there, it's all, documents that they're looking at versus an actual building that they're examining.
okay, so in this case, is there anything else we needed to accomplish at this hearing to move us forward? We've looked at the RFQ, we're moving forward on it. We don't have any other items that we need to cover. Oh, actually, so I will take any public comments at this time. If you have a public comment, please raise your hand. If you're on the phone, you just hit *9, and I'll give you a minute to decide if you want to make a comment at all. Okay, it's a quiet bunch. We haven't had that in a few weeks. So let's see. Okay, anything else from the team that you want to state?
No, just to clarify, so have you authorized Kathy to issue the revised RFQ and I think
Oh,
the board.
sure, right. So
the
Kathy,
board-
should we make a motion and vote to reissue the RFQ? Do you need that?
No, I mean, it's clear all from a nod of your heads that that we'll be reissuing it. I think the only thing that well, before you close out, Carrie, is that you'd need to continue this public hearing.
Yes, okay. So we have agreed to reissue the RFQ as we discussed this evening, with the pending dates of right now, we're looking at the 23rd. So I think we all agree on that. Yes, everyone's okay with what we're doing? Reissuing? Okay. All right, great. So that's taken care of. We don't have any additional public comments. Any additional comments from staff?
No.
Okay. Stephen, you had some other comments in your letter that we didn't address this evening. I don't know if there's anything else that you wanted to address at this time, or?
I thought we covered most of what's in my letter.
Okay, I'm just making
Did
sure.
I mention you can't regulate the use? Just kidding.
You've never said that before. I will say, Stephen, sometimes we don't always see eye to eye, but I think you're respectful and you serve your client well. So I hope that, we walk away and still have a good environment for ourselves.
Thank you.
Anyway, let's see. So then with that, does anyone want to make a motion to make a motion to continue the hearing? When should we come back? When does it make sense based on this timeline?
Well, you'd be, the award is actually, and Fred also just reminded me, I think I have a holiday in here. The 11th, November 11th is Veterans Day, I believe. So I'll, I can just adjust that by a day or so. So if you, if we look at, in-house, we would be doing interviews probably the last week of October. Checking references. I think no, oh no, November 3rd, we can't meet because there's an election that day, if anybody doesn't know. So we would probably be looking at your meeting in November 10th.
Oh, do we actually have one on the 10th?
Well, that's groundwater, sorry. Oh, good Lord.
Could we meet after groundwater, or is that not possible?
What time's ground? Well, we don't know what's on groundwater for that night
Oh,
at
okay.
this point. See, that's the, because we have one webinar license.
Mhm.
So, no, but I need it in a host. So we're,
Can we do it the day after on the Wednesday? If it's the 11th or the 11th, a holiday.
well, what I'm thinking though too is that, you're awarding the contract, but then then they probably have 30 days or so to do the work. So you wouldn't have anything until probably the beginning of December, to look at and you might have something sooner from the consultant. But as far as being able to, have any kind of worthwhile discussion. So you might want to just look at, and I know we're doing this out loud and this sounds like it's a little inefficient, but you might want to look at November 17th, continuing this. No, because you're not going to have anything by then. Going into December, I'm sure is killing the applicant, but
So when do they come back?
well,
Interviews
the award, I have the award being issued basically, the week, November 4th, that's the middle of the week. And then, typically it takes about a week for the consultant to start work. And then you assume it's about a 30-day project for a review of this kind. So, that brings us to, the contract is done the second week of November. So that brings us, to the third week of December. It's for a month.
You'd always just put it on the first week just in case, right? And then we could continue it or something.
You could.
In
The-
early or
You have meetings on right now on December 1st and December 15th. I have a conflict on the 15th. And I was actually going to, I didn't think that we'd be talking this far in advance, but it does make sense. I was going to talk to you in November if you wanted to do 1 or 2 meetings in December. But the 5th, I do have a conflict on the 15th already. So I could look for another date that week for you to see if the webinar license is available and if there's a host for the meeting.
I
So
think we
like
should,
Amy
because-
said, you could put it on December 1st and then we can go from there.
Kathy, can I just clarify when our meetings are? Because I am either off by a week or I'm looking at the wrong calendar because
So-
we're here in
So
the,
in October, Millie, you would be the 6th and the 20th.
how is that? Because today's the 15th, so the next meeting we have is the 29th, correct?
No, you meet the 1st and the 3rd Tuesdays.
Oh, it's because there's an extra one. Never mind.
Yeah, so there's a 5th Tuesday that the ZBA already grabbed.
All right, never mind. Thank you.
Yep, so you're meeting the 6th and the 20th, and then in November, you ordinarily would meet the 3rd and the 17th, but the 3rd is the election.
Yep, okay, all
Um,
right. That cleared me up.
And then December, you would meet the 1st and the 15th, and I have a conflict on the 15th.
Okay, so does it make sense to just say that the December 1st is the
Yep.
first available date?
Yeah,
that makes sense?
Yeah, I think it makes sense to say December 1st. And then, certainly there's going to be a lot of work that happens between now and then. And we can, go accordingly.
Okay.
Now, and the applicant has to be
Oh, does
amenable to that.
December 1st work for you?
Yeah, I was confused. What would happen on December 1st?
Well, we're picking a date as to when to continue this public hearing.
Okay.
So
Because
I
you'll-
do,
yeah.
go ahead.
You'll award the contract earlier than that.
Yeah, the contract,
Okay.
the way I have the schedule is that the contract would be awarded November 4th.
Okay.
And then, anticipating that the consultant could start, within a week.
Yeah.
So that they would be starting, I don't know how I started this on a Wednesday instead of a Monday, but I can fix that. So that they would be starting on the 11th of November.
Okay. So
Okay.
we just need a date to continue the hearing to. There's,
Yes, that's fine.
And
Thank
so
you.
I'm saying, Steve, that on the 15th, I have a conflict in December. I mean, that probably, that would have been the more likely night,
Mhm.
but I have a conflict. And in the meantime, if the board, continue it to the 1st, but if the board wants to meet that week of the 14th, I know the 14th's taken, but I can see if the 16th or 17th is available.
okay. So in the meantime, so that just in case that doesn't happen, does the first sound like something you'd want? We should at least meet before the end of the year.
Yes, thank you. Yeah, the 1st is fine.
Okay, so why don't we say December 1st at 6 PM?
Mhm.
Okay, so does anybody want to make a motion to continue the hearing for 425 Whitney Street, special permit site plan approval and special permit for groundwater protection overlay district to December 1st at 6 PM?
So moved.
Okay, is there a second?
Second,
Okay, motion's made and seconded. I'll take a roll call vote. Millie Milton,
Aye.
Amy,
aye.
Anthony,
Aye.
Michelle,
I,
and carries an aye. So the hearing is continued until December 1st at 6 PM.
Thank you. Thank you for your
Okay.
time.
All
Great.
right, thanks.
Thank
Have a
you.
good- Move everybody out. Okay, and now we are back to old business, which I think we actually covered, unless Kathy, do you have any A&Rs, lot releases, or bonds?
No, I do not.
We haven't really talked about goals, and I don't think anyone's prepared to do that tonight, so I'm gonna pass that. And then any subcommittee updates? We haven't done that in a while, actually. We haven't had time. Millie,
So-
any updates from, oh, go ahead, I'm sorry.
I was just going to say, Open Space has been working on their long-term plan for open space and recreation for a better part of, I think, close to a year now. And after a few surveys and a lot of work, internal work, the plan is, as it is going to be presented in an open forum on Zoom tomorrow night at 6 o'clock. And so everybody's invited to participate. There's going to be a presentation, and I think there's going to be a segment for feedback. So that's it with open space.
Okay. Any, Millie, do you have any reports from CPC?
No, just, well, that we do have a scheduled meeting coming up on Thursday to go over an application or requisition for funding for the Housing Authority.
Okay, and so your deadline, what's the deadline for applications?
I think it's November 11th.
November 12th.
Well, I was close.
Yep,
Okay.
very, very close.
And if anybody wanted to
That's good.
submit an application, is that just something you find online, the town website? How would you
Yes.
go about that?
Mhm.
Okay.
Yep, it's on the front page.
Okay. And if you're just submitting, does it have to be like is it similar to here where you have to show up with like a site plan? Not, I mean, obviously not a whole site plan, but.
Yep, it's a full-blown application, and the applicant needs to have met with the town administrator beforehand to talk about procurement and project management. And then the applicant also needs to, or should have met with, the respective committee. Like say, if it was a rec project, they should have met with the Recreation Commission, and obtained a letter of support. So that's all due November 12th. And then we haven't scheduled the hearings yet. That's something that Millie and the rest of the committee will discuss Thursday night, but most likely the hearings will start in January.
Okay. Anthony, Anthony already went. Anything else, Millie, from CPC?
That's it.
Okay, Michelle, anything from design review?
no, we have the applicants tomorrow night,
Oh, a nighttime meeting.
nighttime meeting, so that
So-
everybody can view it.
You know, we have to resolve at some point is our terms.
I know. I
Yeah,
have that stuck on my
terms and-
computer, Carrie.
Yeah, and we have to do, we have to update some of the design review standards that we need to work on.
Okay.
Yep.
So eventually we'll get to our to-do list.
Yeah.
Anything else from,
I just want to say, Kathy, before we wrap up tonight's meeting, on the subdivision that we were talking about earlier, can you upload that into the, those, the waivers they request or those emails? I was just sort of poking around. I didn't see anything on the minutes and stuff, but maybe you just have them on emails that we can upload it to our general mailboxes and have those.
What
But
what
the
is it?
applicant asked for the waivers. Remember, we couldn't come up with when they asked the emails
The
for the zero Bartlett Street subdivision.
oh, for the continuance?
Yes, yeah.
Yeah, I have
Not waivers,
down
I'm sorry,
that,
the continuance, yeah.
to add the continuance request.
Yeah, I see the one that Mark Donahue noted it in the, I think, August 18th minutes. And then he was gonna send the request the next day, but I couldn't find that first one. when I
Right,
looked
and
it
that,
up.
yeah, that's what we were talking about before, that
Yeah.
I couldn't find in the folder, but I have it as an email, and yeah, that'll go online.
Yeah, I was just searching for you to see if I
Yep.
could help you along and,
Yeah, I'll put that up, Michelle.
okay.
okay. Anything else, Michelle?
No, I'm good.
Amy, anything from groundwater?
We met, I think, last week, and as we talked about, 399 Hudson is a duplex. It was approved through groundwater as long as it's only 6 bedrooms. So it goes to ZBA next, and then it will be in front of us. And the other one was 56 Hudson Street, and that was actually continued. I think the applicant's going to be meeting with Fred and the fire department just to get more information.
Okay. For CMRPC, I went to the quarterly meeting, which we covered unconscious bias and diversity in planning, the start of an important dialogue. Did you get to see it, Kathy? Did you see the
I
presentation?
haven't yet,
Oh,
no.
I'll see if I can get a copy of it. It was a nice presentation and obviously
I bet
very
it
relevant. Yeah.
I bet it was.
So they did a nice job with a couple of different speakers that just talked about just like a subliminal bias that plays into planning in ways that you don't expect. So that was interesting to see. So I'll see if I can get my hands on that presentation and share it with the board. One thing I'm looking at, did I miss a subcommittee? Nope. We still have an RFQ. We still have the Bartlett Street peer review to talk about. So I almost skipped that one. Okay, so do we, let's see.
So I had sent that, and I don't know if people are prepared, Carrie, or not, but it's very similar to, because what I started with was a very standard peer review, RFQ when we started the 425. So it's basically the 425, but without all the specifics about, the references to 425 Whitney Street. So if that's, whether you want to look at that tonight or whether we want to do that on the 6th, because, again, you haven't officially voted on,
Right.
if you are going to do peer review, and if you are, what you're going to do it for.
Okay, so does that make sense to everybody else that we don't need to discuss that? Obviously the dates would change because I think they're
Right.
predicated on an approval. Okay, so we're gonna hold then on that. And then Kathy, any updates from you?
No.
Okay, okay, and then I don't think we have, before we had looked at, I don't think we're prepared to really talk about it tonight. It's been on our agenda so long. The 435 Whitney Street, discussion of previous decisions. That's probably, I don't know if anyone has anything to say on that.
That was something that Amy had asked to add, and if you want, I can leave it on, or if you want, I can take it off, and then if you want to discuss it, I can, put it back on.
I can discuss it right now. It's just a question I want to ask them, but without, I'm not trying to compare it to the new application, but there were some conditions on 425 West Whitney Street, 425. And
Wait, you mean 435?
435 is actually the new one. 425 is the old one. I think it's supposed to say 425.
No, 425 is the new one.
Oh, okay. So 435. Sorry, I'm like
Right. 435 is
The
what
old one.
used to be known as Isomatics.
Okay.
And, now the sign out front is, says Steris.
Okay. So my question on that was, there were some conditions on the original permit from them, and they were supposed to be submitting reports to the planning board. And I think we came to the conclusion that those reports aren't being submitted. So, and it has to do with ethylene oxide that's being released into the air, and they were supposed to do air quality, I think, reports. And we just wanted to ask Steris if they've been doing them, if they've been going to the fire department, or if they just haven't been doing them, and if they haven't, why not? But when we talk about the new application, it's hard to bring that up because it's not like I'm basing the new application on it. I'm just curious because when I was looking into Steris at the very beginning, I noticed on the original conditions that there were reports supposed to be coming to us, and I haven't seen any of them. So that was my question. I don't know if we can ask them off the record or if I should ask them, that would be now December 1st. I just wanted to discuss it, and I don't know if it's with staff or with Steris to find out about the reports.
Well, I mean, the planning board, you know, I'm not, for tonight, I mean, I'm not familiar enough at all to even talk about what was supposed to be in the, you know, what reports they were supposed to submit or not. But I mean, that, you know, we can, if the planning board wants to move forward and ask, well, if you want to, first of all, maybe look at the 435 decision, I can dig that up and send that to everybody. And then you can figure out what your questions are. And then, you know, an official letter could come from the planning board, you know, to the owner.
Yep. And it could be as much, I think they tried to say once, or they did say once that the process had changed. So, I mean, it could be as easy as that as the answer, but I just think as a planning board, we should get the answer because if they're supposed to be doing the reports, then it's something we might want to start again.
So I'll send out the decision to everyone, you know, between now and your next meeting. And then we can go from there
Sure.
for people,
Thank you.
for people to review it and then whatever your questions are.
Mhm.
Okay, great. Anything else on that?
Nope.
Okay. All right, great. So Kathy, do we need to solve meetings because we have some issues? Is that something you would have wanted to ask us about?
Yeah, because we, you know, we are getting into the holiday season already. So again, we're good for the 6th and the 20th of October. Not good for November 3rd, but we are for November 17th. So if you want me to, Mondays are always taken and Tuesdays are always taken. So if you wanted a meeting the first week of November, I can look at the 4th or the 5th, you know, to see if the license is available and that a host is available. So that's the first question.
Mhm.
So that you end up with 2 meetings in November. So
Mhm.
that's a question. And then in December, you know, again, it's the 1st and the 15th. I can't do the 15th, so I could look to, if you wanted to meet on the 16th or 17th, you know, again, license availability and host availability. If you want me to do that, if those dates are good with you.
Any thoughts?
I definitely think we should do December 16th or 17th, just because we were talking to Steris and there might not be anything done on the 1st, but there could be on the 16th or 17th. So you hate to put them off until the beginning of the year.
The one thing I'm thinking is that, you know, now we're at the end of the year and we're in a weird predicament where we just had town meeting, but we need to prepare for the next town meeting. And we really haven't talked about, you know, had a conversation about bylaws or, I don't know. I mean, maybe town meeting won't even happen in April, but I assume we have to prepare as if it's coming in April. I don't know, is there any talk, Kathy, about what that looks like?
Not yet. No,
Okay.
there hasn't been any discussion yet. We will probably at our next staff meeting next week, I'm anticipating that we would start to talk about the budget process. So that sort of kicks off, you know, a discussion about the town meeting calendar. So let me see if I can get some information there and then bring that to the next meeting.
Okay. So either way, I mean, I think we need to, we haven't talked about bylaws at all, and this is the time period. Last year, I think we were already in public hearings with CMRPC for solar. So any thoughts on, from the board on that? If we want to, maybe we do dedicate a meeting to talk about it so we can at least have that time.
I have a few, and I know Bob and I have talked, that we've got a few, again, just call them housekeeping, it's not changing the intent of anything, but, after a while you noticed, oh, that's not the section. It should have been this section that was
Mhm.
reversed and someone just typed, just, mixed up the letters. So there's a few of those, that I've got on scrap pieces of paper. I haven't put those together yet, but, so, I mean, I just have some, some people would say they were insignificant, but that's, but I haven't worked on anything major at this point.
Okay.
But can we focus on first just the meetings? Does December 16th or 17th, is everyone okay with those if I can find, if
Mhm.
those are available? And then the same with the first week of November? Or do you just want to stick with one meeting in November? Which would be the 17th.
I think we add the 4th or the 5th because we're going to be talking about an RFP for Bartlett and who knows, I just think we should have it on there in case something gets continued, or I just think it's safe to have extra meetings. And if there's nothing on the agenda, we can always cancel.
Yep.
Okay. So you're going to check on the 4th and 5th of November and the 16th and 17th of December.
Correct.
Okay. Okay. Let's see. That's all, I guess, unless anybody has anything else. Okay, Kathy, do you need anything else, or that was it about the dates?
No, I'm good. Thank you.
Okay, great. Okay, so then is there a motion to adjourn the meeting?
Make a motion to adjourn.
Second.
Second.
Okay, just a roll call. Millie,
Aye.
Amy,
Aye.
Anthony,
Aye.
Michelle,
Aye.
and Carrie's an aye. The meeting is adjourned. Thanks very much, everybody.
Bye,
Thank you.
everyone.